Ready? Okay. Good morning, ladies and gentlemen. My name is Harry Hippler. I'm the assigned special magistrate in these proceedings. I'm going to call to order these hearings, so we'll have roll call. If you could just, for the city, announce your appearance for the record. Thank you. Go ahead.
Mary Carico, clerk.
Nasli Cardona, Code Clerk.
Harry Hippler, special magistrate.
Chief Code Enforcement Officer Jocelyn Ramirez.
Code Enforcement Officer ERIK RICHWAGEN.
Okay, I think that's all. The city attorney will be in and out. Right now she's not here, but she'll pop in when necessary and the like. So I'm going to go ahead, adoption of the minutes as stated in the agenda for the dates November 17th, 2021, October 20, 2021, October 20th, 2021, February 16th, 2022, and March 16th, 2022. I'll go ahead and adopt those. Any deferrals, additions, or modifications, or, go ahead.
Yes. Chief Code Officer Jocelyn Ramirez, case 4467 will be postponed till the August meeting. Case 460 complied on July 1st, 2022, so we're going to remove that case from the agenda.
Great. Okay, what I'll do is, if you're going to testify, if you could just raise your right hand and stand. If you can't stand it, just stay seated, whatever your pleasure is, but raise your hand.
Mr. Hippler, did you have anything?
Oh, I'm sorry. Sorry.
Yes, for case 6952, they are in compliance as of 7/19/2022.
Always nice to hear about compliance. Thank you for your efforts. Okay. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? If you could affirm, please.
Yes.
Okay, great. Go ahead and be seated. What I'd like to do is go over how these hearings occur. For those of you that have been here before, you know how they're run. They're informal. For those of you that are here for the first time or maybe second time and you don't recollect how they go, I'll go ahead and do that. If you could please turn off any cellular phones to avoid interrupting these proceedings. There are also no weapons of any kind permitted in these chambers or anywhere within these facilities. In all issues that come before the special magistrate, we ask that everyone show mutual respect for one another by listening quietly to each person speaking, and that everyone refrain from any clapping, heckling, or verbal outbursts in favor or in opposition to a speaker. These are hearings conducted by special magistrate, the purpose of which is to give any alleged violators the opportunity to contest the decision of the code enforcement officer, which resulted in the issuance of a civil violation notice. These hearings are what's called conducted in a quasi-judicial manner. And as a special magistrate, I'm not a judge. You're not in circuit court. You're not in county court. The regular rules of evidence do not apply. Hearsay evidence is admissible. My goal and responsibility is to act much like a judge in a court and to hear the cases, but I'm not a judge. Just keep that in mind. And to hear both sides of the case, the city, which will go first and present its testimony and evidence and any documents that it has, and your position as well. And obviously, these hearings are open to the public and they're being recorded as well. It is required that all persons who testify to the facts of the case be placed under oath, including the code enforcement officer. If for some reason you didn't take the oath, let us know and we'll do that again. I saw that most people or everyone did, and they stood and the like. These hearings will not be conducted in accordance with the formal rules relating to evidence and witness testimony, as is the case in court. Any relevant evidence will be admitted if I find it to be competent and reliable, regardless of the existence of any common law or statutory rule to the contrary. All documentary evidence must be submitted for placement in the hearing file. So if you have any documents and you refer to them, please make sure that the city gets a copy so it's put in the file as part of the record. And that's for your protection as well as the city's. No documentary evidence will be considered unless the alleged violator or code enforcement officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in direct examination. Also, to impeach any witness regardless of which party first called him to testify, and to rebut the evidence against him or her. It is my responsibility, after I hear both sides, the city side and your position as well, your side, to make findings of fact based on the evidence of record. The fact-finding determinations of a magistrate are limited to whether the alleged violation occurred, and if so, whether the person named in the civil violation notice can be held responsible for that violation. I may also modify the decision of the code enforcement officer as to the time for correction contained in the civil violation notice, even though said time is rebuttably presumed to have been reasonable. That means that after the city makes a recommendation of 10 days or 30 days or 60 days, I may decide to make it more or less depending on what the facts warrant, or if you have a legitimate reason for it to be longer, I'll consider that as well. The goal of these proceedings is to obtain compliance, and that's really part of the bottom line here. I have the authority to assess and order the payment of civil penalties and fines, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code enforcement officer's decision, I must find that there is substantial competent evidence that the named violator was responsible for violation of the relevant section of the code as charged. If I affirm the decision of the code inspector, my order will specify the amount of the civil penalty, that there are violations or a violation, and the administrative costs of the hearing of not less than $100 if assessed, and the date by which the violation must be corrected to prevent resumption of continuing violation penalties, if any, which means, and I just said that earlier, you'll have a certain amount of time to comply. I will, as a matter of course, assess the $100 administrative cost. I think that's really very fair of the city. These proceedings take time and funds to proceed and to obtain compliance if there's a violation that's been proved. An aggrieved party, including the city, may file a final order of a special magistrate to the Circuit Court of Appeals. Such appeal should not be a hearing de novo, but shall be limited to appellate review of the record created by the magistrate, which means that what you put into evidence here or state on the record or documents is what the record will be. If you wind up appealing a decision, you cannot supplement it by further testimony in circuit court, which is where these go for appellate review. An appeal shall be filed within 30 days of the issuance of the order sought to be overturned. If you are found guilty of the civil violation charged, as I said, you will be assessed an administrative fee of $100. The city representative will present their case first, and then you'll have an opportunity to cross-examine if you like. Then you'll present your side of the case. Thereafter, after I listen to both sides, I will then consider the evidence or render a decision after all arguments are heard. All right? This time we'll go ahead and start the public hearings, and I'll defer to the city as to who it wants to call first. Usually we take attorneys first. I think we've got one there. He has a tie on and a jacket, so presumably he's a lawyer. So anyway, whatever. Go ahead.
We have an attorney present.
Okay.
And so we'll begin with case 6184. So I will present my case first, and then you may go.
Yeah, what number would
6184, and that's on page 5 of the agenda. That's section 10.4.
O'Toole? Okay, great. Thank you. Please.
Okay. Chief Code Officer Jocelyn Ramirez, case 6184, property owner Edwin D. and Jean O'Toole, Jean Marie, sorry. Site address 211 John P. Lyons Lane, Pembroke Park, Florida. A notice of hearing to confirm fine was sent out by certified mail on June 24, 2022, posted to the property and town hall on July 7th, 2022. So the town's motion is to confirm the fine. The fine accrued to $16,450.
$16,450. Okay.
And I may add the property is still not in compliance.
Okay, great. All right. We had a final hearing, and you outlined it there and the dates, and now you're just seeking to confirm the fine. All right. You're up. Your name for the record and address and all that good stuff.
Thank you, Mr. Hippler. My name is John Hinden. I'm an attorney with Hinden, McLean, and Arbiter. We are located at 4430 Southwest 64 Avenue, Davie, Florida, 33314. We did file a notice of appearance and motion for continuance in both of the cases here. And if I may, I'd like to present a little background, and I realize we have a lot of people here,
Yeah.
and I don't want to take up too much time, but I think this is important. So first of all, my law firm. We were the attorneys for the town of Davie for 25 years. I was the code enforcement prosecutor for Davie for all of those years, so I've been in a lot of these proceedings. We were the ones, actually, that one of the first South Florida cities to follow a Tallahassee well-known firm, Neighbors Giblin, that came up with this procedure. Used to be code enforcement boards. We determined that we could do this by special magistrate. Davie was one of the first cities in South Florida to adopt the ordinances to give you your gig, basically. So we were one of the first ones, and now, of course, all the cities have done it.
Is that good or bad?
I don't know.
Okay, there you go.
It was interesting when you had 11 code enforcement board members
Right.
from different walks of life, but now we have somebody that's usually legally trained hearing these cases. So
Okay.
there's good and bad, like
Yeah,
everything in life,
that's
right?
true,
That's
yes.
true. So I've been in front of a lot of these. I also have this niche practice where I represent 150 mobile home parks. So I've probably been at every special magistrate in South Florida city and county. So just a little bit about me
Sure.
and my firm. We know this process. We are not hostile to the city or Chief Code Enforcement Officer Jocelyn Ramirez. We understand what your goals are. You serve a very good function for all the municipalities and counties. Without code enforcement, we'd have the wild, wild west. My client, Edwin O'Toole and Jean O'Toole. Jean O'Toole is right over here on the right. She's 87 years old. Edwin passed away in 2013, kind of a local legend. Everybody knows him as Digger O'Toole. He's been here a long time. He had this seal coating business. Well, let me back up and tell you, Digger O'Toole was one of the first SEALs, but they weren't called SEALs back then. They were called underwater demolition teams. They were the guys that swam underwater and placed demolitions on ships and ports to blow up the enemy's facilities. That was Digger. He also caught the biggest blue marlin ever caught in Bimini, 971 pounds. So Digger's known all over. He's had a seal coating business forever here. And that's when they bought this property in 1972. They've had this property for 50 years. So I want the magistrate to be aware of that. They've owned this property for a long, long time and been doing business out of it. When they bought it, you couldn't even get back there. It was a locked gate with a dirt road. There was an abandoned go-kart track with a bunch of Australian pines, this tallow plant that had this terrible stench around it, and they constructed a chain link fence and were first operating the business out of a trailer. Eventually, they paid off a mortgage and then built the building that's been there for, I don't know, longer than 30 years. How did this, now, Gene, look, I realize, you know, we asked for a continuance because frankly, we haven't really been able to dig into everything yet. We're extremely busy. I was aware of this case 1 week ago. That's when we filed our notice of appearance. Jean O'Toole, who's sitting over here, you know, her husband's been, you know, gone to the beyond since 2013. She's 87. You know, I know this has been going on since 2021. I saw the August notices, but frankly, I don't think Jean knew what was happening. You know, I've had my parents both pass recently and went through some periods of dementia and just old age. And you know, if I wasn't looking at their mail, nobody would have been. So Jean's children, you know, and family became aware of this very recently, and that's when they hired me. They said, John, we know you've got this huge background with government and code enforcement. Try to help us out. So just to address, you know, the background of how this case started, it's almost, first of all, they aren't doing much business there anymore. You know, that they're actually trying to sell this property to somebody that would make use of it because, you know, as you can see, Jean is not really operating a business anymore. How this case started was somebody stole a car and they parked it on their property and lit it on fire. That's how this happened. And it caught the fence that they've been there for 30 years, this wooden fence. It isn't a new fence, so that is one of the facts that are wrong in this case. This fence caught fire. So they hired a fence person to come out there and try to put it back together, replace the damaged wooden slats, and that's when code enforcement, well, I guess they probably saw the burned car first, but they came out there and a whole litany of things resulted from that. So there are some things that we are and will, I say we, my client are and will, now that people who know what's going on are aware of this, they're going to fix the things that can be fixed. The paints, the fence is going to be repainted. It's not a new fence. It's been there for, everything that's there has been there for 30 years. You know, everything that, look, Digger had any records. I know some of my clients' children have had communications with the town about records. I know this from Davie. I don't know if it was Wilma or one of the Cat 1 hurricanes that came through here, but we used to store our law firm's records because we were the town attorneys with the town in a warehouse in Dade County, and one of those storms came through and flooded that warehouse. And so the town and my law firm has no records that predate that flood. I think it was mid-2000s. I don't know if Pembroke Park has that same situation. Nothing was online back then. So a lot of those records are missing in the town of Davie. It appears, for whatever reason, that the town of Pembroke Park doesn't have a lot of their old records. You know, nobody can find the building permit for these structures that have been there for 30 years, is what I'm being told. But that building's been there a long, long time. I have no doubt that Digger built that building with permits when he first built it, and everything that's there. You know, Digger has been gone for 8 years, so we're not going to get that information from Digger. We're not going to get it from Jean. Apparently, the town doesn't have its old records. So, you know, again, we could prove by aerial photographs it's been there for 30 years. Here's what I would suggest, without diving into too much. Again, I'm not here to be adversarial to code enforcement supervisor Ramirez. She's doing her job. It's a hard job. I remember when I was the prosecutor for 15 years, people aren't happy when you're citing them for violations. I get that, but that's what keeps the city looking good. So a lot of this my client can clean up. You know, there's trash and debris. They can clean it up. What else did they tell me about? Hold on one sec. There's some canopy issues. They can demolish those canopies. That's their plans. They're going to come in there and do everything that they can to get this property at least looking good again and remove the stuff that's problematic. They're talking about ordering a new section of canopy for the west end of the building. Again, the problem with the wooden fence and the chain link fences, they can restripe the parking lot. That's what they do for a living. That's part of what their business is. So that's easy. You know, some of these things that the city's requesting after the fact permits for, you can't get them because when this was built 35 years ago or whatever, it's not code now. And that's my understanding of an after the fact permit. It would have to be code now. I'm sure it's not code now, but it was code when it was built. Right. So what I have requested, what I would say would be fair, and again, I haven't filed anything with the special magistrate. I simply didn't have time. You know, when this thing appeared on my desk, I was supposed to be in mediation this morning. Thankfully, that case settled. That's why I'm here. When we told you we had these conflicts, my partner Sean's at a trial in Daytona. I was supposed to be at a mediation in Broward County, case settled, okay, I can go. So what we think is fair, is we would like the town to vacate the final order that was entered. Again, I understand, I'm not contesting that you did what is required under Chapter 162 with regard to those notices. I'm telling you, that meant nothing to my 87-year-old client. You know, that went right over her head. It wasn't until her children got wind of all of this that you started hearing from us. So we'd ask that all of those fines that had accrued be vacated and give us a time to comply with as much as we can. And we'll be working with the town and with Ms. Ramirez, you know, to determine the things that may be difficult to comply, these permit issues. I just don't know yet how we're going to resolve that. I mean, look, sometimes I have a closing that's supposed to occur that we had a right-of-way issue, a $10 million closing, and we reached out to Broward County, and they found an unrecorded 1946 Broward County resolution that vacated this right-of-way. At the 11th hour, it's like the Hail Mary pass, we're able to close. So, you know, things can be found. It took them a month of digging around in Broward County's records to find this unrecorded resolution that the lender was objecting to. So it may be that we can find these records about what was built 30 years ago on this property by Digger. And or whoever his contractor was, nobody knows. Again, his children were fairly young at the time, so they don't have any knowledge about that. And Jean, frankly, I love her. I've known her for a lot of years, but we're not going to get it from there either. So what I would make an or tennis motion to do is to set aside those final orders or amend them and give us time to comply. You know, 60 days I think is reasonable for us to dig around, to do the stuff that we can do immediately, and we'll get all that done. The clearing the debris, the fixing the canopy, the removing the other canopy. I'm looking at my client's list, and to try to dig around about these permit issues, because that's the real problem, you know, and look, at the end of that time period, we'll know where we are. We fully intend to you know, I've been through the process. I think we've got one pending right now where you come after the fact, after compliance, to mitigate, some cities call it, or reduce the lien amounts. And I know it's typically like an 85% reduction because you got to cover your costs. Look, this is not free.
90%.
Yeah.
And if you're on a good day, I give even more. So
And I appreciate
don't,
that,
if
Mr.
somebody-
Hipler.
That's okay. Yeah.
So we will make sure the town gets compensated for its time. You know, that's important. You know, you cost money. Ms. Ramirez gathers a salary. All these folks here are paid. We understand that. That will happen. But what we'd like is, instead of this lien running up, we'd like just a chance, now that we're on the case,
Right.
so to speak, to have 60 days to comply. And then within that 60-day time period, you know, we'll be talking to Officer Ramirez about, okay, this stuff's all been complied with. Here's what we found on these, you know, that's the problematic part about this case, is these 30-year-old permits for these structures. You know, can we find records of them? Can we find some proof that they were all properly permitted when they were built? And then if we can, that solves all those problems. You know, they've been there, they were permitted, they stay there. They have to be maintained, clearly. So that would be our proposal, Mr. Hipler, and
All right.
that's really my speech.
I appreciate your candor. You're obviously a high A+++ lawyer.
Thank you, sir.
With your background. Let me tell you what my position will be. And I've reviewed the photos now. I also spend time beforehand in a cursory manner looking at most of these cases. The property, as far as service, I think a green card was sent. I don't see a signature, but it was posted on the property. So query whether or not you even have to post if you send a certified notice. According to the statute, gives options. But here, the town did it both ways. So there was posting. I'm looking at the property, and it does not really look like it's in great shape. It needs a lot of help. And for example, I noticed that like the parking, which if that's what your client's firm or one of her friends or somebody can take care of and whatever the violations are. I'll give you another example. Let's assume, for the sake of argument, that there was a permit for the fence. I'm looking at the fence. There's a wooden fence here that either deteriorated over age or was not maintained through nobody's fault. I mean, if it's 30 or 40 years ago, then ultimately, from what I understand about the case law in Florida, that even if there was a permit entered, if the fence can be repaired without it being putting a new fence in, fine, you may or may not have to get a permit. On the other hand, if it has to be not only maintained by putting a new fence in, even if there had been a permit granted 30 or 40 years ago, you'd still have to go ahead and comply with getting a permit for that issue. I'm just pointing out with the fence, the wooden fence, there's also a chain link fence. There's also the burned car that just really needs to be removed immediately. The
Car's
fire.
been removed? Okay, thank
Yeah.
you. The car is gone.
Oh, it is gone. Okay,
Yeah,
great.
it was removed by Broward Sheriff's Office.
Okay, all right.
I think it was a criminal investigation, so we couldn't
Oh,
touch
good.
it.
Okay, well,
Because it was a stolen car.
okay, well, that maybe saved your client
Yep.
some money,
Yep.
so that's great.
And that's how this all started, right there.
Yeah. Yeah, but
Some
the-
criminals left
yeah,
that
well,
there.
you should thank him here, but not thank him for whatever else.
Yeah.
I believe I'm bound by the original order that was entered. This is a motion by the town to affirm the fine. Usually, hearing the confirmed fine, usually in those instances, I don't even get into the facts
Understand.
of the case.
I do.
So what I'm going to suggest is and I appreciate your argument about an Ortenis motion to vacate due to her age, and she just wasn't aware, but she is now. So I'm going to leave the original order intact, and I really don't think I have a choice but to affirm the hearing to confirm the fine at this time. If you think it'll take 60 or 90 days to get everything in order, then quite frankly, you should get everything taken care of as quickly as you can. The purpose of these hearings is to put some teeth in them to make people move along. And unfortunately, sometimes the only way to do that is to assess a fine and keep it going until. And when there's compliance with everything, which it sounds to me is forthcoming, then you can come back for a mitigation or an abatement. And quite frankly, under those circumstances, I think you can argue that, she wasn't aware of what was going on, but, it happened, you moved expeditiously, it was a piece of old property, but I have to go ahead and affirm the hearing to confirm the fine, in my opinion. I mean, I know that I signed off on the first one, but whether it would have been me or another magistrate to really vacate it, I think would not be the right course of action. But just get it done.
Just understand,
Yeah.
Mr. Hippler, for the record, we contest some of the factual allegations in there, but again, I'm not here to
I
attack
know.
Officer
Look.
Ramirez. I'm here to try to get my client, at least make the town aware.
Yeah.
We're aware of this, we're on it. If that lien has to run until we fix and then we come back and abate or mitigate, which I know is your standard procedures, just
Oh,
like
yeah.
every other municipality.
Yeah.
We get it. We just want to make sure that you understand this is not, nobody's sticking their head in the sand about
Oh,
this.
no.
We're
Okay.
going to take care of it.
Then get it done, and that's really the best course of action. As great of an argument as you made, and as A+ of a lawyer as you made, and how candid you were, and all the other stuff, it just needs to be done. The property just looks like it's
Needs fixing up.
more than that anyway, but get it taken care of. I looked on the Broward County Property Appraiser's office. I mean, that listed it maybe value 120, 130. I don't know what it's worth.
I don't know
Usually
either.
that's on the low end. You
Yep.
can't really rely on what that
And I
is.
think the plan is somebody's going to come, look, Jean is not going to run her seal coating business out of there anymore. That's slowly drifting away. You know, they did it for 50 years or whatever it's been, a long, long time. But, you know, life goes on like that, as we all know. So somebody's going to come in and utilize that property for which it's intended, whatever the code and
Right.
permit. And I'm sure it'll be looking a lot better, but we're not going to wait till that happens.
Right,
We're going to
don't.
make sure that the things we can take care of get taken care of now. We'll be in communication with
Yes,
Officer
please.
Ramirez, and then the permit situation, we'll just have to sort out the best we can
Right,
and
and-
go from there.
But just so you're aware, I have seen case law or periodicals or, you know, supporting case law and suggestions that even if there was a permit for the fence, even if there was a permit for the other things, if there's deterioration, it's not a permanent permit. You have to go out and maintain it. I mean, that's what code is about. As much as people don't like it and say, well, somebody's pointing a finger at me, it keeps the property values up. There's a limited amount of law review and legal periodicals that say that. But what if we did have the wild, wild west? Then it would look like
Look
terrible.
horrible.
So just
Understand,
get it
Mr.
done.
Magistrate, we
And
appreciate your
If
time.
it's me in the future, I'll remember what you argued. My memory hasn't gone that bad yet. You know, the day isn't over.
Nor mine, but it's coming.
Well, yeah, probably,
We
but
still,
I'm
we still have to go and,
The next case.
yeah, to the next case.
Same argument.
46.
Yeah, same argument. I
Which
believe
is
46 is more specific.
Section 10.5 on the agenda.
Same arguments, Your Honor. I would
Okay.
just incorporate my arguments on I believe the older case is only 2 violations. And really that's more about, you know, there is a reference to a site plan. I'm sure interestingly enough, just an aside, one of the cases that I have taken to circuit court was Deerfield Beach, where they cited my client for noncompliance with the site plan, but the city didn't have a site plan because Broward County was the one that approved it back in the 1960s. So we did go before Judge Lynch. We appealed our loss at the special magistrate, and Judge Lynch reversed that. And there is a reference in here to a site plan, so I don't know that the city has a site plan. It's site plan or building regulations, I can read too. But, you know, there isn't, to my knowledge, the city has not produced a site plan to tell us why we're in violation of that. So again, as a legal matter, I would contest that part of it. But in general, it's the same arguments, you know, about the building and the permits, and I understand. I don't, again, want to take up too much more time. You got a lot of people here, so I will rest on that note.
Okay.
Mr. Hearing Officer, I just want to enter my appearance as Town Attorney
Sure.
Nancy Anderson. I do want to point out that the final order was entered in 2021. The time for appeal or motion to vacate has long since passed. So I think I would agree with the hearing officer's recommended course of action, which is to get some sort of game plan together and then come back and discuss the code at the appropriate time.
Nice to meet you, City
Okay.
Attorney.
If I
Thank you.
may, I would like to present my case, 6546.
Sorry about that.
Okay, that's all right.
Chief Code Officer Jocelyn Ramirez, case 6546. Property owner Edwin D. and Jean Marie O'Toole. Site address 211 John P. Lyons Lane, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail on June 24, 22, and posted to the property and town hall on July 7th, 2022. The confirmation fine is for $27,350.
Okay, I'll go ahead and confirm the fine for that one as well. Your arguments have been incorporated into this case, that's fine, no problem there. But just go ahead and get it done. It's really the most cost-effective way to handle these matters. The city is really gracious in mitigations or abatements or reductions of fines. All cities don't do it, unfortunately. I wish they all did. some are really hardcore. And
That has been our experience with Pembroke Park.
Yes.
They are like the town of Davie when I worked
Yes.
there, very gracious. They do the right thing. As you noted, this is all about compliance.
Of
It's
course,
not a
it is.
fundraising
Right,
issue.
exactly.
So I understand, and I may communicate with the city attorney or town attorney, as we used to call ourselves, about, how we maybe can search for these old public records, these permit records. I don't know if they're, again, Davie lost all theirs. I think it was Hurricane Wilma that happened. I don't know if that happened to Pembroke Park, but that's the real problem, is
Okay.
these old records.
See what you can find, and we'll take it from there, but there needs to be maintenance.
Understand.
The quicker that happens, the quicker it can be listed for sale in this still very hot, low-interest environment and get it done. It's business property, not
Yep.
a place,
And
but
the happier these folks will be. I understand.
exactly.
Yes.
Okay.
Okay.
Thank you for your
Thank you.
courtesy. Ma'am, you have a great lawyer, okay?
Well,
You do.
thank you, Mr. Hip.
Thank you. All right, thank you.
Have a great
Take
day,
care. Be safe, everyone.
Mr. Hinton,
Yes.
were you also going to present case 4467?
This new case, yeah, Mr. Hippler incorporated my arguments, 4447. There's a third case?
I just wanted to make sure that because I know that you said that you weren't able to appear today.
Yeah, well, originally, when we filed the motions a week ago in both cases, I'm aware of two cases, 6184 and 61, is it, let me get the case numbers
Okay.
right. So there were two cases that I was aware of.
You had a mediation.
6184 and
but the case
6546.
settled,
Yeah, we
Okay.
filed notices of appearance and motions for continuance in both. I had a mediation this morning. My partner had a trial in Volusia County. My case that was subject to mediation settled on
Okay.
Monday.
All right.
That's why I said, okay, I'll come here and so same arguments. I believe Mr. Hippler has ruled in the same way as he did in 6184.
Right.
But again, our goal is to circle back to you as quickly as we can. And then we'll come back whenever the
Right.
time is right to apply for abatement or mitigation of these accrued liens and fines.
Great. Thank you so much. Good
Thank you.
luck. Take care. You too, ma'am. Want to say anything further, or is she?
I don't think there's anything else.
Okay,
I'm going to
great.
let the rest of these folks get on with their day.
Okay, thank you. Take care. Thank you. Bye.
Okay, thank you very much.
Is there any other attorney present in the audience? Okay, we'll proceed in chronological order. Next case is 5717. That's on section 8.9 on the agenda. Chief Code Officer Jocelyn Ramirez, case 5717, property owner Alex Pierre Lewis, site address 5500 Southwest 32nd Street, Pembroke Park, Florida. A notice of hearing to abate fine was sent out certified mail on July 5th, 2022, posted to the property and town hall on July 6th, 2022. It is the town's motion to abate the fine of $47,350 by 90%, which will be a total of $4,825, and it includes the administration fee.
How severe were these? Exterior maintenance of structure and premises, repairs and installation. Okay, I got you. All right, your name, please?
For the record, my name is Alex Pierre Lewis, property owner 5500.
Okay, talk to me.
First of all, Special Magistrate, thank you for taking the time, and I appreciate the city abating the fines. I have done my best to comply with all requests from the city in regards to the property. I've had the worst experience in dealing with contractors and empty promises and having to learn how to work with the city and how to comply. my goal has always been to comply with the city. I did my best personally to clean up the property. I helped with the paint personally. I even installed some dummy cameras to prevent illegal dumping on the property. I purchased no dumping signs, placed them at the property. I myself would take out the trash, grab a pickup truck continuously, and with the aid of the dummy cameras and continuously picking up the trash, I stopped the illegal dumping on my property. I had previous tenants who did not pay rent, and I had to file a notice of eviction with them. I had another tenant who abandoned the property, and during the course of the past 2 years of the pandemic, I had some financial hardships. I even hired one contractor who took off with a deposit. In my efforts to maintain the property, I actually broke code by putting up a fence, which I had to learn the hard way. You can't put up a fence. And then even with putting up the fence, my contractor, and I have this documented here, charged my credit card, and I'm disputing with the credit card $6,500 to put a whole new fence, which I did not approve the charge. And I had to dispute that charge with my contractor, and I have this documented here. And then simply to find out, I could just do a demo on the fence. And my contractor was giving me misinformation that I could not do a demo on the fence. I've outlined 10 financial reasons why this amount is a little bit too hard for me. I do understand that Jocelyn and the court and the city has spent time and has allowed me a lot of time to fix the situation. And as Jocelyn would tell you, I have done my best to comply. I have done my best to fix everything that I personally could. And if I had to hire a contractor, hire a plumber, I did. We're at the point where we're pretty much, I think, resolved with all issues and all citation, and I'm in compliance. I am asking the city to lower the amount, and I want to comply. I have a IRS issue where they're trying to place a levy on my properties. I have the tenants who vacated the property without paying. I gave a contractor deposit who left and abandoned me with the money. My personal business is marketing for municipalities, marketing for special events, outdoor festivals, concerts, and of course, during the past 2 years with the pandemic, business definitely decreased, so my income has decreased. I was a victim of identity theft in 2022, in 2021, and 2020. I have the police reports here. They went into my account, took money from my account, and I have a copy of the police reports here. My parents are retired. They're in their 70s, so I'm the man of the house financially supporting them. So for all these reasons and more, which I have documents here, I'm asking the city to lower the amount.
Well, what amount are you asking the city to lower it to?
A realistic is $1,500 would be something that I could make a payment plan on and pay.
Looking through the file and here, you've outlined your reasons verbally. This was going to be set for foreclosure, I believe. This might have been one of those cases last month or the month before. Then it's not set, so the town is giving you another opportunity to take care of this. There's now full compliance. Is there a mortgage on the property?
Yes.
Broward County Property Appraiser's Office says it's worth about $225,000. That's probably on the lower side. It is on the lower, because these things, County Property Appraiser's Office doesn't come up with they say just market value, but you need an appraiser. Are there new tenants in the property now?
No. It's the same tenant, and one side is currently vacant.
But you're looking for a tenant, right?
Correct.
And these are residential tenancies?
Yes.
Okay, I think the most I can do here, because it just took a long time and with all the efforts, is I'm not going to go with the 1,500. The town has reduced it 10%, 48.25, but I'll give you a further break. I'm going to go with an even $4,000. All right. So, how long do you need to pay it?
A year.
A year? Well, that's not gonna do, all right. You know, business for you is gonna get better, is, even though, there's still COVID running around, you know, based on what you read and the, how red it is on some of the maps on the news media. Like, still, people are out and about. You'll rent the other side as well. So, what's better than a year?
Lowering the amount, I mean, two more issues. I do appreciate it all, but two more issues I have is I had a, what's it called? Lender forced insurance placed on the property because I defaulted on paying my insurance payment. Like, that's where we're at with this property. Like, I also defaulted on paying the insurance on the property, which was canceled. So the lender forced an insurance, which brought up the mortgage.
Right, yeah, okay, that's unfortunate, but at least, I mean, they want to be covered, God forbid, just in case something happens. Fire or destruction, they're a mortgagee and the like, so, what amount is the city's position, is it firm, like, I know 4825?
The max amount we have given in the past is 120 days.
Okay, all right. I'm gonna go with 120 days as well. You're just gonna have to come up with it, that's all. And it's been reduced now more than 90%, probably closer to 95%. So, I just can't in good faith go any lower. It's not that, you know, I know what the Florida case law says, and the amount going from 47,350, which incidentally, if the city wanted, could legitimately argue based on Florida and federal case law, is not excessive and is reasonable. I mean, there's just a bunch of case law. I didn't write the opinions.
I'm learning.
I don't agree with them, but I'm bound by it. So going to 4,000 even, I think is really fair, and you're just gonna have to find a way to come up with the.
And Mr. Hippler,
Yeah.
one other issue that I had, and I guess this is just me needing to learn, and I'm sure maybe a lot of property owners here have to learn. My contractor told me once the building permit was filed, then all daily fines would stop. So I was under the impression that the minute the building permit was filed or registered, the proper term with the city, then from that day, daily fines are put on pause. And as I found out the hard way, that's clearly not it.
No, that isn't it. When there's an order entered that has to be getting a permit and getting the permit closed, which means approval by the town, the municipality, the local government, that's when it ends. It continues to accrue, because just because you get a permit filed doesn't mean that there's going to be compliance unless it's stated in the order. And I'm sure that what it did, it said that there would have to be compliance, not just getting the permit. Or that's what I'm saying that it said or should have said, or I'm sure it did say that. So it didn't stop. It you know.
Yeah.
I'm aware of no authority that would allow a magistrate to stay any daily fine. You know, you're not asking for that, but I'll just throw that out. So I try to keep up on this stuff because I find it fascinating, interesting, and I hopefully can do people some good, even though they may not agree with the numbers. So 4,000 within 120 days. And you can probably work something out with the IRS these days if money is owed. That's between you and them. Wasn't that way in the olden days, but I don't know for sure. So it's 4,000 within 100.
If not, it reverts back to its
Revert back, right, okay.
back to the original amount.
Okay.
All right, thank you very much. Good luck to you.
Sir, please hold on a second and we'll give you the copy for your order.
Next case is on 8.1.
Go ahead. Oh,
Case 1031. Chief Code Officer Jocelyn Ramirez, case 1031. Property owner Dominic Vendetti, Sylvie Desrochers. Site address 131 East Lakeshore Drive, Pembroke Park, Florida. A notice of hearing to abate fine was sent out by certified mail on July 5th, 22, posted to the property and town hall on July 6th, 2022. The fine accrued to $24,218.50. It is the town's motion to abate this fine by 90%. The total amount is $2,754. And that includes the administration fee, the levy fine, and the recording fee.
okay, what was this 10.1, did you say, what number?
1031.
1031, all right. Okay, yes, go ahead, please, sir.
Good morning. My name is Bertrand Sesset. I'm the property manager of Park Lake Estates. I'm here on behalf of Mr. Vendetti, who's in Canada. With this case, when Mr. Vendetti bought the house in 2019, he was not aware that there was a problem with the town of Pembroke Park. This was an issue with the previous owner who had done some repairs on the small wall outside of the house by the patio. And she opened the permit, she closed the case, everything was fine when he purchased the house. He never heard anything from the town until June of 2022, when he received a letter saying there was a foreclosure, and that's when we started to discuss with the town what could be done to avoid this situation. So also the owners, the previous owners were very sick, were old, and they couldn't come for 2 years. And that's also one of the issues that happened when he bought the house. Like I said, it was regarding a small wall. The cost of the repair was probably less than $3,000. If Mr. Vendetti had known that there was an issue, he would have taken care of it right away. He did make sure the permits were closed, but he didn't know there was an issue. So we would kindly request that the amount of the fine be reduced to 5% if possible.
Say your, I see an address here, Pembroke Park, posted. They're in Canada.
He's in Canada, yes.
When's the last time they were here, did you say?
He was here this winter, but he only received the letter in June for the foreclosure.
Okay, all right. Come down for the winter to this property?
That's correct.
Okay. All right, there was a code violation, no permitting, you know, the way the law is written, it's strict liability. If you're the owner, you're stuck with whatever was done or should have been done or wasn't done. That's just what the law is. There's only one exception to that, which doesn't apply here, but it's just what I've called strict liability, so.
But when he bought the house, the permit was open and closed, and all the work was approved by the town.
Okay, what, do you know what he's talking about the permit? If you
Yeah, the permit was completed, so we stopped the fine.
Gotcha.
You know, the final order was on January 25th, 2018.
Yeah.
They were given about 60 days to comply. but the fine accrued for 477 days from March 27, 2018 to July 17, 2019 at $50 per day.
Okay. All right, this is a condominium or a townhouse or what?
It's a mobile home.
Mobile home?
It's a mobile
All right.
home.
All right. What I'll do is I'm not going to go with the 5%. I think that's just way too low. I will do it. I'm going to make it 2,500 even. Okay. Payable, how long do they need?
That's another thing. Can we get 45 days because he needs to send me a check from Canada?
We'll do 60 days.
60 days. Thank you.
Okay, 2,500 within 60 days. Now they'll be able to enjoy it even more without the threat of foreclosure.
Yes,
so
definitely.
I'm going to bait it to $2,500.
If it's not paid within that time frame, it reverts back to the 24,218.
Okay, thank you.
Decido.
$2,500 within 60 days or it reverts back. So it's a no-brainer, okay?
Definitely.
They
Thank
need
you
to
very
pay.
much.
Thank you. Good luck to you and
Thank you.
them as well. Thank you for your help.
Next case is on section 10.2, case 5384. Chief Code Officer Jocelyn Ramirez, case 5384. Property owner Robert and Deborah Feeney. Site address 5501 Southwest 34th Street, Pembroke Park, Florida. A notice of hearing to confirm fine was sent out by certified mail on June 29, 2022. Posted to the property and town hall on July 6, 2022. It is the town's motion to confirm the fine of $14,000.
Yes, ma'am. Go.
$14,000 for what?
The last time that you were here, you received a final order on September 15, 2021. So there's a per diem fine if the property is not in full compliance.
Okay, you asked for the roof, it was done. I did the fencing, it was done. Last time you came over, the only thing you complained about was the part of the fence, which it got done this weekend, and I called you yesterday to come and look at it, correct? Did you come by?
Nope, not yet.
I left you a message. You told me come before the 20th. And I did. I called you up. As a matter of fact, I called you today, and I left a message with you. Did you get the message?
I haven't received my messages yet, but I am going to work on them.
Okay.
You know, the day before the magistrate is a very busy day for us.
Okay. Well, it was done. The fence was done. The roof was painted like you wanted. So the only
Okay.
thing you complained about was just the twigs, and that's a lot of money. I mean,
Okay, so I will have to do a reinspection.
okay.
Okay.
Yeah, because I mean, like I said, everything was done. I wish I would have taken the pictures with me and
Yes.
stuff like that.
Well,
and
they still,
everything.
man, they still need to go by and verify.
Yeah,
These were a bunch of, there were 8 violations. If you complied with most of them, she'll
Yes.
come by there are two people there.
Yes.
Lots of cases, so
Yes.
nobody is, disregarding you. It just takes time and,
Yeah, okay,
giving
that's fine,
somebody.
and I
20
removed all the vines off the fence.
Okay, or well, ma'am,
Okay.
she'll go by there and verify
Okay.
all that. When that happens,
Okay.
then it'll
The
stop.
only thing that's left is just because, they pick up the garbage, and I trimmed the tree back that she wanted, because it's true, it was obstructing the stop sign. And trying to fix the fence, I had to cut it way back. I had to cut that tree way back, because it was just embedded into the fence line. So it's no longer obstructing anything, but I didn't cut it completely down. It will grow back, okay?
Okay.
Okay.
If I can make it late this afternoon,
Okay.
I'll pass by. If not, it'll be tomorrow
And the only thing
morning.
that's left is a few twigs inside of the yard, and they dumped the garbage today, and I will be taking care of that whenever I get home from work.
Okay.
Okay.
This code officer and the other one, they need to be an octopus.
Yes, I understand.
Really.
I understand.
can't- I know,
You
I'm
know,
just.
it's just that whenever
I
she
know.
said that fine, it kind of shocked me,
Well,
that's all.
ma'am, you watch this, you can come back and ask
Yeah.
for a reduction if you want. If you don't want to, that's up to you.
Yeah, no, I'm gonna ask for a reduction,
Okay,
because I
all right.
can't afford that. I'm not renting the property, we're living on it, and I'm
Okay.
not making any kind of income from there.
Yeah, I know, but if you're living on it, that's great.
Yeah.
So, all right, so I'm gonna confirm the fine at $14,000, and that'll be that. So, see what happens, all right?
Okay. So when am I gonna know about the 14,000?
When she okays it, all right,
Okay.
all right.
Okay,
Thank you, good luck to you, take care, there you go.
Okay, next case is on section 9.2. And that's case 6832. And my apologies to Paul Neal. I had missed the case before. Okay, Chief Code Officer Jocelyn Ramirez, case 6832. Property owner Drew Boy Inc. Site address West Hollandale Beach Boulevard, Pembroke Park, 5590. Notice of formal hearing to extend time was sent out by certified mail on July 1st, 22. Posted to the property and town hall on July 6th, 2022. The property owner has a few items that need to be taken care of, so it's my recommendation, since they've been showing good faith in complying with all the items, to give them 30 days to complete the remainder of the items, if not a $250 per diem with a $100 admin fee.
Great. Any objection?
Oh, that's fine. And the compliance is just seal coding and
Well, I still haven't received a phone call in regards to the trimming of the trees.
trim. Okay.
The permit for the parking lots, they have to be completed. I know that all the work has been done, just has to be inspected by the building department, as well as the fence that was installed.
I think they're giving us that today for the fence. Okay.
And that's pretty much it.
That's pretty much it. Okay.
Keep making progress so that you don't have to see me again.
Exactly. I appreciate it.
Unless you like seeing me. No. Rather
Yeah, I
not.
don't-
Hey, I don't take it
I
personally.
don't mind.
It's okay. I don't mind.
I don't
Good
mind
luck,
at
all right?
All
Get it
thank you very
done,
much.
all
Thank
right?
you, Jocelyn. Okay.
Thank you, thank you.
Discuss the cases.
Do I need to get anything?
Yeah. Oh, sure, what happened? Oh, 30, I'm sorry, did you see that? Well, that's okay, within 30 days, all right. That's okay, that's why you get paid to do it.
Next case is 6833, which is also Paul Neal.
Yeah. These two cases. Yeah.
Chief Code Officer Jocelyn Ramirez, case 6833, property owner Drew Boy Inc., site address 5590 West Hallandale Beach Boulevard, Pembroke Park, Florida. A hearing to extend time. Notice was sent by certified mail on July 1st, 22, posted to the property and town hall on July 6th, 2022. This open violation is similar to the last case. They still have the few items that needs to be corrected, which is the tree trimming. The permits have to be completed. So my recommendation is to give them 30 additional days to comply, if not $250 per day with $100 per diem.
Same lecture, same ruling.
Same ruling.
Yeah.
Thank you very much.
That way you won't say one's 30 and the other one's 35. They're both
35, okay.
30 days, okay? All right. Just
Thank
get
you very
it-
much.
That's a good luck to you, all right?
Okay.
Hey, 250, did I put 250 in the prior one? Prior one for the gentleman, do I need to put 250 to write it in? Okay, that's okay, I got, oh, you did it?
Next case is on section 9.1.
Junior time.
That's case 6727.
Give me 1 second, please.
Okay.
There you go, thank you, that's okay, that's all right. Morning.
Just give me one moment. I'm going to present the case and then you may go, okay? Okay. Chief Code Officer Jocelyn Ramirez, case 6727, property owner Hallandale 4520 LLC, site address 4520 West Hallandale Beach Boulevard, Pembroke Park, Florida.
The number like 9 point whatever or 8 is.
Yeah, it was 9.1 on the agenda.
Thank you very much.
You're welcome. A notice of hearing to extend time was sent out by certified mail on July 6, 2022, posted to the property and town hall, July 6, 2022. Veronica, she's the property manager. She has been working diligently to correct all 19 items. So far, there's probably like 2 items that need to be corrected, which is some business tax receipt from a couple of tenants and some permits that they have to complete. So my recommendation is to give them an additional 45 days to complete the items, if not a $250 per diem with a $100 admin fee.
Good morning.
You're up. Good morning. Your name, please.
Veronica Perez.
Into the microphone. I can do it.
Veronica Perez.
I hope everyone can hear me. I talk loud anyway, but okay, great. Go ahead. Yes, ma'am.
Yeah, we actually we are working in 2 permits. One is for one of the tenants that they already opened a permit a long time ago, and since they are not getting along with the contractor, I actually took care of the permit, and I'm doing a change of contractor And then the other one, it was a tenant that did some additions to the store. Then they left without notice, so I'm taking care of that. And once I finish with one of the permit, the store, which is a Metro PCS, they will get the license. But they can get the license without the permit being closed.
45 days additional time, is that okay?
Yeah, I believe it's
Okay.
going to be okay.
All right, I'll go ahead and extend it for 45 days or $250 per day thereafter. Okay?
Okay, thank you so
Good luck
much.
to you. Thank you.
Case number 6720. Mr. Magistrate, it'll be on page 6, agenda item 11.4. This is case number 67220. Property owners identified by Hollandale Mobile Home, Yano Cruz and Mary Patterson. The site address is going to be 3140 West Hollandale Beach Boulevard, Lot 520, Pembroke Park, Florida, 33009.
Good morning.
Good morning. I'm going to present the case first, sir, and then...
Sorry, I
No,
think
that's fine. I'm just going to present it, and then you can speak, okay, sir?
Okay.
Okay. All right. The notice of violation was issued on 2/4/2022, sent out regular mail on 2/7/2022. The notice of formal hearing was issued on 7/5/2022. The affidavit of service, and it was posted to property and town hall on 7/7/2022, and certified mail on 7/5/2022. The violations were for interior structural work that was done without a permit, electrical work that was done without a permit, an addition that was added to the mobile home without a permit, windows that were installed without a permit, and mechanical plumbing work being done without a permit, and prohibited outdoor storage. It is my recommendation to give them 60 days to come into compliance, if not a fine of $50 a day with a admin cost of $100.
Your name, please, sir?
Jânio Cruz.
Closer to the microphone. dude.
Jânio Cruz.
Okay, and what would you like to tell me?
What I like to tell you is, there's a lot of stuff I don't get it. Because I take the fan out, and I take the electrical box to paint, and then I put it back. So, and I do fix my wall inside because no look good. So the shed there for 7 years, some Canadian guy leave the shed there, go to Canada and die. So 60 days, I'm good to fix this. I can fix this today for tomorrow, I do. And I don't have to see again, like you say.
Okay, you're going to need to get permits for a number
Exactly.
of these.
Yes, well, if you actually scroll up to the picture I took, he did interior, work that requires permits.
Right, okay.
So he's going to need a few permits.
So, but I like to you guys, please tell me, how about inside my house? I don't understand.
Inside that somebody did work, and so did you do work inside your house?
I don't do work inside my house. I do repair my wall I have so bad and I paint. And
I know, but
don't
if
think
it's a
anything
wall.
inside
Mr.
my-
Magistrate,
Go ahead.
if you want, the picture shows what I'm discussing. When the picture was taken, as you can tell, there was interior work done. If you were to go up a little bit, if you look
to fix my
in the
wall
back, there
for
was
sure.
electrical and plumbing work done.
I don't do any electrical. I don't touch any electrical. I swear to God. And in front of you, okay? I don't do electrical.
Okay, how long have you had that home?
I have this home 10 years ago.
Okay, they're saying you have done work without permits, electrical and the wall and the other items. So,
But inside my house, I don't do electrical. I don't do electrical. I swear to God. Okay?
all right.
How about the shed? I understand. You give me a couple days, I get the permission, and I take him down. I don't care. The window there for 10 years. Okay, so please, do the re-evaluation over there and see what I have to do. I don't have no problem to do. Please help.
Your position is still the same, right?
For the time,
Yes. Yeah. Okay, that there was work done. He's says he hasn't done the work. How old do you think the work is that was done there, if you can estimate?
I mean, when the picture was taken, you know, it looked like there was work going on quite recently from the
Okay.
picture date.
All right. Yeah.
So you guys can help me to fix this. I want it done like.
I know, but you'll need to get a permit for the inside work.
Please, I don't work inside my house for, I don't review anything there.
Sir, I was there at the time. You were removing drywall and putting in new drywall, so that requires a
You
permit.
find any 4x8 there, like whole 4x8?
Drywall
You
requires.
find a small piece outside and take the picture.
You had the
You
drywall
guys-
up, so you have to get a permit
You
for the
guys go
interior.
in my window and take a picture to inside and my property.
Okay,
Sorry. Right or wrong?
correct,
That's correct?
correct, as is
Okay,
presented
so-
to the magistrate,
And
yes.
then you guys say electrical. How come electrical there?
Well,
Everybody have to take the
electrical,
fan?
electrical, we're not gonna touch the subject. We're just gonna confirm that it was drywall. The electrical will be up to the structural inspector, who will inspect the work that you did when you obtain an interior renovation permit. That's what you need to obtain.
So I have to take the permission?
Interior renovation permit from the building department, so that means you gotta show plans of the drywall that you removed and put in. So you have to show that plan now.
So how come I'm gonna show and I do already? I have to broke again and do again?
It could be, but you have to talk to the building department. It could be that you have to remove a piece and show how you put it on the wall. You gotta show the screws, the wood,
The wood.
yeah, the wood that you pieced the screws with.
See, the thing that I
It's
don't.
very difficult.
Well, sir, here's the problem that I have. I'm going to affirm what the town wants, and you're lucky, fortunate, it's only $50 a day. But you're saying you didn't do any work, then you back up and say, well, yes, there was
No.
some work, the drywall, among other things. So either you're not understanding, or you're understanding and you're saying that you don't do the work. So they're saying you need to get the permit. When the city inspector comes in, the code officer comes in and says that this was work that was done, they can usually estimate how and when it was done, not to the exact day, but say within a year or two, or a month or two, or whatever it is. You need to get the permits, okay, for the interior work. Did you say that there was a fan here or not?
No, I have a fan there before. I take fan for the paint my ceiling. That's how I do. And the little box do the switch stuff. I take the tap to paint, and I paint and I put it back. That's why I say what the electrical I have to do in my house. The drywall, it's done already.
Okay, but if you,
Because
there is if you're messing around with an electrical box, you shouldn't be doing that.
I know, but I don't know this. I swear to God.
You may not know it, you know it now, but you don't mess around with anything
No,
electrical.
I know, but
Look,
now I know.
that is one of the most dangerous things anyone can do, is mess around with anything electric. You're liable to hurt yourself, and you're liable your neighbors, all right? So I'm gonna go ahead, okay, thank you for your response, and the city's
So I do have a
educating.
60-day to.
Yeah, and I'm gonna find there's substantial competent evidence to support the city's position. You'll have 60 days in which to comply. Do you think $50 a day is enough, or do you want to, or increasing that?
I'm gonna go with the $50 a day.
Okay, I'll follow that. You're fortunate, because quite frankly, there's work that's been done. This is something, it's very doable. You look like you're diligent, you'll get it done. but don't do it get permits before anything is done, all right? It's for your own safety. I mean, you want to put your hand in some electrical box with circuits and, you know what could happen. You're not going to be like Benjamin Franklin in the olden days with a kite, okay? You might not be so lucky.
Okay,
All
thank
right.
you. How
need-
about the windows?
The what?
The windows there for 10 years.
The windows?
Yeah, I never changed window too.
If they say you have to do it, you're going to have to do it. You're going to have to do everything they tell you to do, all right? If they go there and say maybe not, that's up to them. They're going to have an electrical inspector come by. Whatever the electrician says from the city, you're going to do. That's the bottom line. It's just really one of the most important things. You don't mess around with electricity, all right? So I'm going to go with $50 a day. You have 60 days to comply, or it'll be $50 a day thereafter.
So from today or from?
From today, you got 60 days.
Okay,
Okay? Good luck to you.
thank you. Have
Sure.
a good day.
Sure.
Next case is on section 11.7.
Code Officer Richwagen representing the town of Pembroke Park. This is case number 7068. Property owner identified by BAM Mobile Home Community, Robert Granger. Site address, 2430 Charles Road, Pembroke Park, Florida, 33009. The property was in violation for additions that were added, concrete pavers that were installed without a permit, the concrete slab that was installed without a permit, the wooden deck that was installed without a permit, and the exterior discoloration on the property. The property was cited on 5/12/2022. The notice of violation was sent out by mail was posted to the property on 5/12/2022. No, for the notice of violation, it was posted to the property. Yeah. A notice of formal hearing was issued on 7/5/2022. The affidavit of service and posted to property and town hall on 7/7/2022. And it was sent out certified mail on 7/5/2022. It is my recommendation to give them 60 days to come into compliance, if not a fine of $100 with a admin fee of $100. And we have Mr. Granger here this morning.
Mr. Robert Granger.
Excuse me, that's Richard Granger.
Sorry.
No, they had that posted. I had it like that. I don't know how they got that.
Richard Robert, what's in the name? You're close enough.
Exactly.
2 R's. Go ahead anyway.
All right, let me introduce myself. I'm from Pittsburgh, PA. I don't live down here permanently.
Are you a Steelers fan?
Gotta be.
Okay. All right. Just curious.
And what it is, I had another trailer here in the park. Bought it 10 years ago. Bad shape. I gave it away. Okay, but because it was in my name, I found this other trailer, purchased it for $35,000. Great shape. But okay, I had my buddy Carl Ellis, who's in his name. I put his name, but I'm a co-owner of it. Okay, because we could not put it in my name because I owned the trailer at the time. You could only own one trailer. Okay, so we never did the split deed or title. This is all new to us. Okay, when we bought the place in 2016, everything was there. The slab, the room, the deck. I did no alternations. Excuse me if I said it wrong. But I did find the deck itself, and I'm not trying to insult anybody here. This is a thing from Florida, permit guides. Says any deck under 200 square feet, under 30 inches, need not to have a permit. And I have this in 2 exhibits, which I want to show to you.
Do you want to add this into the file? Okay.
Now, immediately, he was kind enough, the gentleman was kind enough, I called him up on, when I got that letter, I flew in here on the 6th. I had this letter, you could not make it out, that was there from before, okay? Nobody could read it, so I flew down here to see what's about. And I was gonna call the township and ask them to send me a copy of it. Fortunately, the gentleman here had it posted on my door while I was at that day. So I called him up. He came out the next day, took me by the hand, showed me in detail what he's talking about. Okay, I appreciate that. So what I did immediately, I said, I got to get the permit to take up the slabs and the deck. And the deck's beautiful, okay? I hate to lose it. So immediately, I went and cleaned and painted. And because I'm a certified demolition contractor in Pittsburgh, and I guess to do things differently, when he told me about the slabs, I said, okay, I'll take them out. They're ugly anyways. So that weekend, I took out one of the 4x8 slabs. I'll take a picture. And then I went on Monday to get the permits. They said I wasn't allowed to touch it. So I stopped the work immediately. And this right here. So my intentions are very well to try to comply as fast as I can.
Okay, how many days then do you?
Well, sir, this is going to cost me quite a bit of money because we understand they want me to hire an engineer to come in here to look at the so-called addition. They're booked up for a couple months, okay? And I called 2 people. I did call a contractor, who I'm going to be working with in the future. It is, I don't know if you can make that out.
Francois McClellan? Francois McClellan, okay.
Yeah, and here's my cards. They used to tear down buildings, got out, renovate schools and everything like that, but since the epidemic, there's been no work, nobody wants to work. I plan on retiring down here this winter. I'm gonna transfer my demolition skills down here to become a contractor.
Good.
And I wanted to comply, and I'm doing my best. I'd like to have an engineer come look at that building. Okay, it's a nice addition, okay, but it was there when we bought it. Okay, we had no idea. This is all new. You know, Pennsylvania, you have grandfather clauses. 10 years, it's in. But the way they complied with that deck, 30 inches and below, as long as it don't have a roof, you don't need a permit. He probably has a permit for that addition, because that's the only 2 violations I think I have right now, right?
Well, the violations are.
And I got to do a little bit of research on it.
Okay, well, here's what I'm inclined to do. I know you bought it as is. It's not unusual for mobile homes. Pembroke Park has a lot of mobile homes. I mean, it's predominantly a mobile home community, but it also houses a lot of great businesses and the like. But I'm probably going to go along with, I mean, you think 60 days is enough time, or you want to?
Since he came down, he's been in constant communication with me. He even had the other property owner, because like it's split between him and one of his friends, so they both want to come into compliance.
Yeah. Okay.
How much time do you need, sir?
Yes, sir, I got to go back to Pittsburgh on the 24th. Okay, I have to try to find some money, but I'm going to keep contact with that engineer. Okay, the engineers, and I'm going to call you up and say I got an engineer coming in to check everything over. If the deck needs to come down, I got a price on it, it was like $3,000. You know, I mean, I could take the deck down in a day.
Yeah, but how long do you need to come into compliance, do you think?
Well,
Is it 60 days going to be good?
I would like 90 days if it's possible, because I'm going back, I'm not sitting here on my thumbs. I got to go back to Pittsburgh, generate some money.
We don't usually extend to 90, but, what was it?
90
Yeah, so I'm okay with that because, again, you stayed in constant communication with me. You've been talking to the building department. You know, you're not, you know, you're showing good faith. You did remove the discoloration.
Yes,
So you have
cleaned
to,
it, painted it.
like I said, just stay in contact with me, but yes, Mr. Magistrate, let's move from 60 to 90.
Great, it's agreeable to me because he's acting in good faith, and he's moving along, and he's coming back and forth. I understand Pittsburgh is one of those great, it's a city that people think isn't a quality city, but it's a very high-quality city.
Very expensive city, though.
Well,
That's why I'm selling my property up there. I'm coming down here.
Well, that's, well, I'm not sure how much of a bargain you'll get in Florida, but, you know, good luck, you know.
No, I know the property down is more expensive, but the property taxes up are outrageous.
Yeah.
I pay $20,000 a year for that, and it's not worth it.
It is. Well, you'll do fine either way. All right, I'm gonna go with 90 days. There's substantial competent evidence. He's moving diligently. He needs to go back and forth from Pittsburgh and to South Florida. I mean, I looked at the photos here and as well as,
I got more
Great.
upgraded photos if you
yeah,
want to see them.
it's a nice looking place, so you.
It's a rental, though. That's a problem. I could put, if it was my property, I could sink 50,000 into it and call it a day. Okay, you know, because I know you're not going to be bothered again. But all the money you put into it, they could turn around in 30 days and say they're selling the park. You know,
Yeah.
and that's what's scary about it.
It is scary, I understand, unless you own the property you're renting, and most people don't, or many don't, so. All right, 90 days to comply or $100 a day thereafter. Work diligently. In this instance, if you need more time, contact the code officer. They're very reasonable. You just need to move it along. And get your engineer to do his thing or her thing and get it taken care of.
Yeah, I'm the same way. Communication is the key.
Exactly. Excellent. All right. Good luck to you. Take care. 90 days, and
If you want to put
or
it in.
$100 a day. Yeah.
$100 per day? $100 fee.
Thank you, Mr. Granger.
Sir, give me one moment for the cup.
I'm sorry, too much caffeine.
6 3 13.
I put that he was here. Is there an X mark? No, just double check something. I put that he, yeah. I put he was here.
yes,
Oh, yeah,
yes.
that's okay. I was double, triple check things.
Six, 3, 13. I don't find this, guys. 6 3 1 3.
Oh, yeah.
No, they wrote the wrong number. It's 5039.
3.
Mr. Magistrate, the next case will be 5039 on page 7, agenda item 12.3. Case 5039, property owner identified by Holy Ridge Apartments, LLC, Elon Property Management. Site address 3215 Southwest 52nd Ave, Pembroke Park, Florida 33023. The violation was that there was new construction on the exterior of the apartment and interior renovation of the apartment without a permit. The notice of violation, this is the hearing to confirm fine. The hearing to confirm fine was issued on 7/5/2022. The affidavit of service and posted to property and town hall was issued on 7/7/2022 and certified mail on 7/5/2022. The total accrued fines is $20,000.
Let's see, this
And-
order says
and-
19,950, so,
It's it's 19,900 with a $100 admin fee
Oh, I
for a
got
total of
you.
20,000.
Okay.
Also, it is still not in compliance
Right.
as of today's date.
okay, got you. Okay, I'm gonna confirm the fine for the 19,950 plus the $100. I mean, they're not here. Holy Ridge Apartments, Elon Property. Oh, I'm sorry. Oh, sorry, go ahead, what's up?
So anyway, Peter Vey,
Yes.
I'm an employee of Elon Property Management that
Great,
oversees the property.
Okay.
So, you know, there's a lot to be said here because it's so old and, you know, this was, you know, the first year and a half, it was a COVID thing.
right,
We couldn't find contractors, and then we couldn't find architect engineers to supply the drawings until finally, like September of last year, I finally got our guy. So there's a lot, he could speak, but there's a lot of paperwork and permits that were put in, change of
Okay.
contractors, new contractors.
all right,
In good faith, we replaced the roof that we felt needed to be done, which has nothing to do with the violation. Permit passed, fine, because we just felt with the work that needed to be done underneath, we needed to start at the top. So I'm just saying that because I want you to know that we've been doing things.
okay.
David might have a word to say
Come
about
on up
where
briefly.
we are.
You know, it's just when you have a hearing to confirm fine, there's Florida law that says that we don't even need to have a hearing, but the city called, but no, talk to me, you know. I'll remember it hopefully until the next.
My name is David Morales. I'm a general contractor.
Right, up to the microphone, David Morales.
My name is David Morales. I'm a general contractor. I was hired by the management company that's running this property. And from March of 2021 that I got involved here, we submitted permits, applications, plans. The building department, we've been working together for, I don't know, a year and a half or two, but it's been very, very complex. Right now, as we speak, I have a revision in the building department that hasn't been approved yet to continue and to finish the project. There's documentation, and you can look at the building department, how many times we've submitted drawings and so forth. From the onset, okay, there were issues with asbestos. We had to go through the EPA here in Broward County, and that took months. So the delay, it's, you know, in all fairness, hasn't been our fault. Or in this case, my fault in particular, that I'm the guy that's running the process, the permitting process. So that needs to be brought into account. And this, you know, we have a daily fine, I understand, or the company has a daily fine, but I think it's like a conflict of interest from the compliance standpoint, and the building department delays. So, you know, and you know, we're paying for it.
We're trying.
I need, the point is, take all this in consideration, and finally, if we get everything approved, we could be done there in, you know, 30, 45 days.
Well, that's for you to keep pushing. There was a final order entered, I think, May of 2021. I mean, it's been now, you know, a month, it's a year, May, June, July, month and a quarter since the final order was entered. I mean, this apparently, correct me if I'm wrong, but 3215 Southwest 52nd Avenue. I mean, just the value on this property says is $6,600,000. So that's what the address is. Maybe it's the entire area. I can't imagine this one building is worth that. Maybe I'm wrong. But I'm looking at the house. It looks like a townhouse with a fence right here. Is that right?
It's modular built apartments. They were built in Sanford, Florida.
Right, and
transported.
Yeah.
Pieced together like Legos.
yeah, okay. Well, then somebody got a bargain then, or except for the travel, I don't know.
I think they were built in '84.
84. All right. So, you need to move expeditiously to get this thing taken care of, and then you can come back for a mitigation or a reduction down the road. But the order was entered May 18th, 2021, $50 a day. It began to accrue around June 17th or 18th. I'm going to go ahead. Anything else that anybody has to say?
October of 2021 is when the building permit application.
Please speak into the mic so we can have this on record.
It
Thank you.
was October of '21 when the permitting process began from my standpoint as far as getting it done. And it's been a myriad of issues. I
Yeah.
mean,
I'm sure.
we can't
But-
begin. But that was a date that actually everything started to get done.
Thanks to you. They need to credit you with that, so. Yes, sir. One last comment.
Well, yeah, we credit him because we finally found someone that's following through, because we've gone through so many people that said, I'll do the job.
They
Then
didn't
they
do
back
it.
out, and once they hear engineer and architect, they want no part of it. And finally, we got someone. So
Good.
we're in progress. I want you to know that, like, the windows installed, the doors installed, the roof's up.
All right.
The plumber and the electrician might even be finishing up if their permits get approved, like this week, because they tell me they applied. It's a new water heater. So, it started with a window and a door, and now it's cabinets, water heaters, everything.
Okay. Well, you'll have a better home there, so. All right, I'm going to go ahead and confirm the fine for the $19,950, so it's the $100 cost. Just get it done, and you can come back.
Mr. Magistrate?
Yes.
It's $20,000 even.
20,000 even. Okay, so I should then cross out the 19,950? Okay.
Yes.
I'll cross it out, and I'll just say 20,000 even. All right. I'll initial this. You don't need to. So confirm it for 20,000 even. Get it taken care of.
Okay. Do I have to wait till the job's complete to request?
Yes. When there's full compliance, you can come back and ask for a mitigation.
Thank you.
That time. Thank you. Thanks for your efforts, sir, the contractor. Take care. Thank you.
Please hold on a second. I will give you the copy.
Gentlemen, we'll give you a copy here that way. Yeah. You can leave it like, let me initial it. Okay, I do it all the time, and that way, and that'll.
Thank you.
Have a nice day.
All right, the next case is on section 10.1. That's case 5325. Chief Code Officer Jocelyn Ramirez, case 5325. Property owner CICF 3, Florida 2W01 LLC. Care of Cabot Properties, Inc. Site address 3400 Southwest 20th Street, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail on July 5th, 2022, posted to the property and town hall on July 7th, 2022. It is the town's motion to confirm a fine of $23,100.
Your name, please.
Good morning, I'm Jesse Oppenheimer, 3400 Southwest 20th Street. We are the glove store, we're the tenant of the building. At the original time this case began, there was a different owner of the building that's named in this case. They no longer own the building. They sold us the building in April of 22. We subsequently sold the building in April of 22 to Cabot, who is the current owner.
Okay.
The original owners were in Brazil. They received the notice apparently. They never told us as the tenant. They didn't tell us in contract negotiations when we were purchasing it till mid-April, or I'm sorry, late March. They said they were going to take care of it. Then by mid-April, it became apparent they weren't going to take care of it, and they were going to buy the building as is, and it was going to become our thing to take care of. We met with the town, with the building department to find out what the situation was and to learn all about it. And it turns out that when the building was originally built, I think in 2016, there was a permit to put in a landline for the fire alarm system to call the county if there is an issue. It was prior to lines being pulled to that part of the Seneca Lakes development. They had no landlines at this point. These drawings were signed off with a landline, but they put in what's called a wireless mesh communicator to talk to the fire department, but they neglected to put that on the drawings. The drawings were finalized with the landline in the drawings, not the mesh communicator. The landline was never pulled in, which we did not know as the tenant. It was prior to our tenancy. The CO was given with the landline not there. We found out about this. We've rehired the original company that did this. They said that they came out and we had AT&T pull the landline. We installed the landline. We got the landline installed. We had the county come back out to run the test. They ran the test. It took 10 seconds to get to the call center, but then apparently the call center sends the signal to the county, and it took just over 90 seconds for the county to respond for some reason, but ours went out in under 10.
Okay, question.
Sure.
Who's the owner now is
Cabot.
CICF 3 FL2W01 LLC in care of Cabot Properties, Inc.
Correct, sir.
Okay, all right. I appreciate everything you're saying quickly because, there's already been a final order entered, and really, the only thing I can do at these types of hearings to confirm fine is approve them.
Understood.
Okay,
Understood.
all right.
And
when
we're
do
doing.
you think this is all going to be taken care of?
We thought it was going to be taken care of about a month ago. So now it turns out they need to buy another module for the system that's on back order, of course, because of supply chain issues.
Right.
But they are talking to the county to see if we can get it approved with the mesh communicator, which we think we can. I guess the gentleman in the county has been on vacation for a week and a half. He comes back tomorrow, I believe, and then Thursday he's going to come back out and inspect. We think that we will have this solved very soon. We understand that we are under the $100 a day. We apologize for any inconvenience it's caused the town.
Okay.
But we're going to get it solved.
Good. that's the bottom line, so that when that happens,
Yeah, to my understanding, there is a permit,
Yes, we did pay we bought it, we got a permit for it.
but it just needs to be completed.
We are just waiting for the closeout to complete. It was literally just, the call took 92 seconds instead of 89.
Okay, perfect.
Like, that's where we're at right now.
All
So
right.
we're trying everything we can. We thought we were done. I look forward to the day when we can come ask for mitigation. I appreciate
Okay.
everything the town's doing to work with us. You guys have been great.
well, it's a shame that you and the seller have a dispute.
It is what it
as to
is.
the-
That's
I
how
know.
things go, and as is purchase. We understand.
Get it mitigated, it's really a de minimis amount of
We understand.
chaos for yourself. There's always gonna be that.
That's how it goes. But everybody here has been great. And we've been
Good.
happy. We do have a second case, though.
Yes, and Eric's going to present that.
Okay.
That's on section 11.5.
Say 11.5,
Yes.
great.
All right. Case number 6980, property owner identified by CICF 3 FL2 W01 LLC, Cabot Properties, Inc. Site address 3400 Southwest 20th Street, Pembroke Park, Florida 33023. This property is in violation of, there were commercial racks that were installed without permits. There was emergency lights that have been installed without permits as well. The notice of violation, excuse me, the notice of violation was issued on 4/26/2022, sent out regular mail on 4/27/2022. A notice of formal hearing was issued on 7/5/2022. The affidavit of service and posted to property and town hall on 7/7/2022, and sent out certified mail 7/5/2022. It is my recommendation, because I know you guys are in the process of completing the permit, so I'm going to recommend 60 days with a fine of $100 a day, if not met, with a admin fee of $100. And Mr. Magistrate, I have been in communication with them. They've kept me up to date, so they're in the process of completing everything. They just haven't finished all the inspections, so that's why I believe 60 days should be sufficient.
Right. And if you're close to the 60 days and
We
you
have
have
no
more
objections and
time,
appreciate that. Thank
then talk to the gentleman. They're both very
No,
fair.
it's been great
Yeah, well,
so far.
so far.
The biggest issue we have on that is that the fire alarm, the fire rack companies, apparently it's going on all over the county, and they're all so busy that just getting them to do the assessment of all the products is taking longer than expected.
Yeah.
But they'll get through it.
Exactly, and you will too. All right, I'm going to find there's substantial competent evidence to support the town's position. You have 60 days in which to comply, or $100 a day thereafter. There is a $100 administrative costs in the order as well, okay?
Thank you.
Thank you, good luck to you, take care, thank you.
Thanks a lot.
All right, next case is 5461, and that's on section 7.5. Chief Code Enforcement Officer Jocelyn Ramirez, case 5461, property owner Yvonne A. Jackson, site address 3838 Southwest 52nd Avenue, Pembroke Park, Florida. A notice of violation was sent out by regular mail on November 24, 2020. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on July 1st, 2022. posted to the property and town hall on July 6, 2022. The violations were for installation of an addition without a permit, installation of a shed without a permit. At this current time, the property owner has been in communication with me since the date of the posting. No permits have been acquired yet. The owner is trying to obtain a variance with the town, but she has to contact the engineers first and then proceed to the variance. So she has various steps to go forward with these addition permit and shed. So my recommendation is to give the owner 60 days, if not a $50 per diem, if not $100 admin fee.
Is your name, ma'am?
My name is Yvonne Jackson, and my address is 3838 Southwest 52nd Avenue.
If you want to take the microphone, you're petite, I'm diminutive, so I know what it is to have a microphone. Go ahead.
My name is Yvonne Jackson. I live at 3838 Southwest 52nd Avenue. And the addition, they said it's illegal. When I bought the house in 2001, the addition was there. And I didn't get any code violation or anything about it. We did our due diligence when we purchased the house to go through what title, fines, or whatever it was that was supposed to be or not supposed to be on the house when we bought it. And then recently I got the violation. They told me that I should knock it down or pay engineer to come and look at it. I can't knock it down because my son and his family moved back because of COVID, they lost their jobs and they had to move back with me. So I'm storing their stuff in that little area.
A shed of some type?
No, it's an addition they put up. When I bought the house, they were using it for a gym or something, an exercise room.
Okay.
So
is this a townhouse or a mobile home?
It's a townhouse by Forest Park Villa. It's a townhouse.
All right.
So they apparently put the structure on it, and we didn't know it was illegal until they told us, because it's on the property appraisal, the drawing and everything is there. And we didn't have any issue with any illegal or code issue or anything like that. So we kept it because we thought it was a part of the house because it was on the drawing and everything. And now they're telling me that I have to either knock it down or get an engineer and so on. So my son and his family are back. They didn't have any money to pay for storage or anything, so I told them to just put their stuff in there since we're not using the place. And so now we're trying to find an engineer or architect, to go and look at it. So in order for us not to knock it down.
Okay, two options. You can either demolish it, and that's an option. The community, how many homes are in your development?
35.
Okay. Do they require you to obtain permission for you to get a variance or to demolish it?
I don't want to demolish it. I want to keep it.
All right, then.
And that's why I was asking about the variance, and they told me I have to do all these steps.
Yes.
So I'm trying to do it, but I'm just, having issue finding the right people. I just took the guy's card to see maybe if he can come and look at it, and I would like more time.
Right. Well, you'll need an engineer and or an architect they want to make sure that it's up to code, but you also need a variance. If you don't want to demolish it, I had one of these cases some time ago where a variance had to be requested, and the woman that owned it has jumped through all the hoops. She wanted to keep it. It was a storage area. She bought it that way. She enhanced it while she had it without permitting. So if you want to do a variance,
I did ask if I could do it, or I think they told me I should. So before I do the variance, they told me I have to get an engineer or something.
Yeah.
I really don't understand all but I wrote it down that I need the variance, the engineer,
you're
then
going to have
bring
to
it back.
you're going to have to get an engineer to make sure that it's worth saving, because if it's not, then an engineer or architect would tell you that it's not up to code or whatever, but you're still going to need to, ultimately get a variance, get permits, and all the other stuff, and it's going to take some time. So,
Yeah, so I would like more time.
I can agree to 90 days.
okay, all right. Well, ma'am, here's what I'm going to do, because my hands are tied. I'm not in this role. I'm not planning and zoning, and I don't decide a variance today. If you need to do a variance, then I suggest that you almost immediately get hold of an engineer. It's going to cost some money, I
Yeah,
don't-
I'm trying.
Well, okay, I know. I'm just telling you what you could do. I'm not going to get into your finances. Hopefully your son will be able to get some work locally, and if he's married, his wife as well. I don't think they expect the two kids to work. Yeah, whatever. Anyway, they're a little young. So,
Thank you.
okay, whatever. But they're going to, hopefully that'll help. But two options: either you do a variance and it gets granted. If it does, even though this will continue to run until that's granted, you can come back for a future mitigation, or you get it demolished. And if you get it demolished, that may be a cheaper way to end the code enforcement per diem violation and fines. So contact an engineer. I mean, go online, go on the internet, ask some of your friends. Maybe somebody in the community you're in had a similar issue. Find out what engineer that they used, if any. And you're going to need an engineer to do this. So my hands are tied, and so I'm going to have to go ahead and find that there's, substantial competent evidence to support the city's position, and give you 90 days in which to comply, or $50 a day thereafter. So if you obtain and move for a variance, that'll have a life of its own. You'll have to apply with the city and go in front of what's called a hearing examiner, and they'll require you to do certain things too. But that's something that an engineer will work out with the city. All right, but you need to do that. All right, so otherwise, consider it demolition. Again, that may be more cost effective for you. And what you do with your son's belongings, I don't know. That's up to you. Either demolition, or you apply for the variance and move that along and hope for the best there, but only if an engineer recommends it, you can do it. But you need to do that. You need to act pretty quickly. Okay?
What's the difference between a site plan and an as-built?
Between what?
Site plan and an as-built?
As-built? I don't know. Site plan is it's a plan of what the property, with drawings by an architect, oftentimes showing building any additions, in this case, non-permitted building that I assume is attached. If it's attached, that may or may not be able to be subject to a variance. It could be, so that's why you need to find out if it's subject to a variance first. So if it is an engineer, and you know who you're going to have to pay and hire, but they will go ahead and do either a site plan, or you will need an architect for a site plan. It just depends. All right, that's part of what they do for a living. So in your instance, I don't think it should be that costly, because we're only talking about small addition. I don't know how big it is, how many feet. With 10 feet, 15 feet, how big is the addition?
I don't know, maybe
know?
about 10.
Okay, I don't know, I'm just guessing, so.
It's a small space because the previous owner, they
Right.
had it for a gym or something like that.
Yeah, okay, well, it was put there improperly. Yeah, I'm looking at the photos very quickly because I want to move it along here.
Yeah, I've lived there since 2001, and it's been there. And I came by and asked for a plan to show, and they couldn't find anything. There's no record of any plans, any permit or anything. So that's like over 20 years.
All right,
And,
well,
there's-
if it's not there, you're going to need to get one. I'm looking at the photo here. There's a addition, and this looks similar to what I was involved in another case, and she filed for a variance, and I believe it was approved. And she needed to do about 5 or 6 things to get it, and then she would come back to code enforcement if she already hasn't, to see what she could do for reduction. Because it took a while. These things don't occur overnight, but it looks very similar. It's an addition here that was put in illegally.
Okay.
I mean,
I don't know how long it will take, but do you think the 90 days is suffice for me to
for
get
now it is.
that?
I'm going to go with the 90 days. If it takes longer, it'll just continue to accrue until there's compliance. If you may want to consider a demolition if that's cheaper and more cost effective. It's your decision, or you may want to do the variance. If this may or may not help the value of your property as well. It probably will help it, especially if you have a permit. Property values have gone up, and with this, it may help even go up more. So
does the $50 per day start today?
in 90 days.
After the 90 days, if it's not fixed, that's when
Right.
the $50 starts?
Right. If there's no compliance after the 90 days, then it starts. But see if a variance is in order. You got to decide that.
Yeah, I put in for a variance. I'm just trying to get an architect.
Not an engineer or
An
both?
engineer, sorry.
Okay.
I'm trying to
If
get
you
an
don't,
engineer.
if you only need one, then get one. All right, if you have both, then it'll be more costly.
An
but
engineer, sorry.
Okay, whatever. Then do it. An engineer may have to do it over again anyway, or they may have to correct things, because sometimes the first time you file something, it'll get kicked back legitimately. No, it just happens. Nobody's perfect. So, all right, I'm going to go ahead and find a substantial competent evidence. 90 days to comply, $50 a day thereafter. It's for an addition. I'm looking at the photo here. So you may be able to do the variance, but I don't know, okay? I'm not making a ruling on that. I don't have jurisdiction, okay? All right, good luck to you, ma'am. Take care. 90 days, $50 a day. Oh, here it is, right in front of me, all right.
Okay, the next case is on section 8.5. That's case 4940.
No, it's 4634, the next, Jenny Sanchez.
The other one, they agreed to the amount, so we're gonna listen it to the end.
Okay. $49.40 is the next?
Mhm. Chief Code Officer Jocelyn Ramirez, case 4, good morning. Case 4940, property owner Brian Geralt and Haseen Shabin. Site address, 123 Lori Lane, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail on June 29, 22, posted to the property and town hall July 7, 2022. This particular case entered into an amnesty program, and so therefore completed all the necessary permits to correct the violation. And we are going to remove the fine of $12,150, and the owner actually paid the admin fee, so it would be a zero
Okay.
amount.
Do you object to that?
I know speak English.
I was kidding, obviously, you don't.
I'll translate what I said.
Yeah, okay.
Yo presenté el caso y estaba diciendo que este caso estaba en el programa de amnistía. Entonces, por ese propósito, estamos cancelando la multa de 12,250 y ya se pagaron la cantidad de $100, que era el costo de la administración. Okay. Entonces él está firmando la orden de abatement y va a ser que no debe nada.
Okay, sir, thank you.
Zero.
Entonces te estaba preguntando si tú estabas de acuerdo con eso.
Perfect.
Respondent shall pay the total sum of 100,000. No, I mean zero. Okay.
Thank you.
Zero, and then within no days, and then to zero. Okay. I'm gonna cross out days, 0 days, and I'll just cross out the 12 that it reverts back. I can just do it that way, no big deal. Or you can call the next case while I do this. Thank you. Just hold on,
Okay.
and we'll give you a copy, all right? But there is a $100 cost administrative fee here. Yeah, okay, is that in here? I don't see the rebate.
Huh? They paid for that.
They already paid? Oh, great, okay. Good, okay, oh, no, you haven't left. Okay, very good, thank you. Next.
All right, the next case is on section 7.2, that's case 5445. There is actually an attorney for this case as well. Unfortunately, he has COVID, or his wife has COVID, so he can't be present here, but he did ask that we give him a call when we present the case.
Okay, this is 7.2, yeah, oh,
Yeah.
great.
Are you presenting the cases, or is the attorney? Both of you? Okay. So let me call him.
Sure.
Hi, good morning. We will begin presenting the case, and I'm going to have you on speaker. I'm going to present the case beginning with 5445, and then we'll move on to the next one, but I'll have you on speaker, and Iris is here as well.
Great, thank you so much.
One moment. Attorneys don't have to be sworn in, correct?
No.
All right. Chief Code Officer Jocelyn Ramirez, case 5445. Property owner Pembroke Crown 3 LLC. Site address 2533 South Park Road, Pembroke Park, Florida. A notice of violation was sent out by regular mail on November 18, 2020. A notice of formal hearing with a copy of the notice of violation was sent by certified mail on July 1st, 2022, and posted to the property and town hall July 7, 22. The notice of violation was that Blanco by Nature White by Mouse Inc. was operating with without a business tax receipt, and they have to obtain a business tax license and certificate of use and complete inspections. They also have to have the certificates displayed in the unit. At this moment, there, as of July 19, 2022, there is no BTR. Therefore, I'm recommending that they complete this item within 45 days, if not a $250 per diem with a $100 admin fee. And I also like to add that this is a repeat violation based on the referencing to the final orders in case 4934 and 4935 that has been entered into the record.
Yes, ma'am, you're up. Counsel, can you hear?
Can you hear, Mr. Shear?
Yes, thank you very much.
You wanna make the argument? Your client is here. She's raring to go.
If it's all right with you, Special Magistrate, I'd prefer to go in the totality for the site. So getting through all three cases, and then I can make my presentation. Or, if you'd prefer, we can go violation by violation.
Well, what I don't understand, you can clarify. This, we're dealing with 5445. This is a no business BTR. No certificate of use, failure to display. Is there any dispute to that particular claim?
So, from my understanding, we have already applied for the BTR. So, and Jocelyn can verify that from the town's end, but we've already applied for the BTR.
Okay.
So we're just waiting now, I believe, from the town.
All right, so you've applied, but you don't have one yet, to your knowledge, ma'am?
No.
No, okay. So if to cut to the chase, if I can interrupt, if I'm interrupting and you don't want me to interrupt, then I'll defer to you, but I'm just trying to move it along. The city is willing to give you 45 days to comply. That really ought to be enough time, well more than you need to comply. So,
Jocelyn, can you confirm from the town's end that you see the business tax receipt application?
Yes, there was an application submitted. Let me see if it was submitted on November 20, 2020. The issue is that, which will coincide with the next violation, is that there was a lot of interior renovation work done. So unless they complete those permits, they can't move forward with the business tax receipt.
oh, okay. I got you. All right, so if they don't do the permitting, get the permitting approved, and for the work inside, then you can't get the BTR. Oh, okay, I got you. Okay, now I understand why
Yes.
you wanted to combine.
Yeah, understood, Special Magistrate. I was on the same page as you were. So,
Okay.
I mean, I think once we get through the other violations, you know, you'll see that, you know, at least from our perspective, that 45 days will probably not be sufficient.
No.
But I'm wondering if maybe we should just get through everything, just so we, you know,
Okay.
are on the same page with you know, the violations.
So what I'm going to do is present the other two cases.
Good, okay.
But either way, we do have to take in count that these have been open since November 18, 2020.
Okay.
So it's a year and a half ago.
Okay, what about the other violations?
So let's,
Have
yeah.
they been,
I'll go ahead and present the other ones.
okay.
So the next case would be 5465. That's on section 7.6. Chief Code Enforcement Officer Jocelyn Ramirez, case 5465, Pembroke Crown 3 LLC is the property owner, site address 2533 South Park Road, Pembroke Park, Florida. Notice violation was sent by regular mail on December 2nd, 2020. A notice of formal hearing with a copy of the notice of violation was sent by certified mail on July 1st, 22, posted to the property and town hall on July 7th, 22. The violations were for interior renovations, tenant build-out done without a permit. A mezzanine was done without a permit. Electrical was altered without a permit. Installation of storage racks were done without a permit. Installed multiple exterior doors without a permit. Removed abandoned sign, which the sign was a sign that they had, it was foundation. A demo permit is required for that. Exposed wires on exteriors of the building have to be capped correctly. At this current time, and as of yesterday, confirming with the building department, there is no permits for these items. So my recommendation, again, is to give them 45 days in count of the, you know, that this has been open since December 2nd, 2022, and it is a repeat violation referencing to case 4934 and 4935. And if not complied with within 45 days, a $250 per diem with a $100 admin fee.
When you said 12 to 21, you meant, not 12 to 22. This has been open since December 2nd, 2021?
No, December 2nd, 2020.
Oh, 2020, okay. Oh, okay, I got you. All right, so this has been open okay, this is, okay. All right, and that's.
All right, and
go
then
ahead.
I'm going to present the next case.
Sure.
The next case is 5466. That's on 7.6 on the agenda. Seven point seven. Chief Code Officer Jocelyn Ramirez, case 5466, property owner Pembroke Crown 3 LLC, site address 2533 South Park, Pembroke Park, Florida. Unit 2575 South Park Road. Notice of violation was sent by regular mail on December 2nd, 2020. A notice of formal hearing with a copy of the notice of violation was sent by certified mail on July 1st, 2022, posted to the property and town hall on July 7th, 2022. The violations were for no business tax receipt, interior renovation done without permit, installation of exterior cameras without permit, a PVC pipe that was added on the exterior of the building, either has to be removed and sealed. unless they can show, what's the purpose of the PVC pipe. If it's electrical, then they'll need the electrical permit. Removal of the abandoned Stratton sign without a permit, and as of yesterday, there is no permit in the system for these items, so my recommendation is to give them 45 days, if not a $250 per diem with a $100 admin fee. Okay, that concludes my presentation for these 3 cases.
Yes, ma'am or sir, who would like to go?
Here, you still there?
Yeah. Thank you, Jocelyn. Thank you, Special Magistrate. This is Jeremy Shear from Becker Law, representing the property owner. And from our end, we also have Iris Wooters, who's the property manager, who's sitting in the audience. And we actually have the property owner, Tony Ross, who's calling in from halfway around the world in Israel, just because he's, it's so important to him that we're able to resolve this issue. And, I just want to state for the record that, from a global perspective, my client wants to work with the town and come into compliance. And I know that Jocelyn and her staff also, are working with us and going to work with us as we move forward. So I think there's been a little bit of miscommunication. And I know that, Jocelyn, you may not have seen it because I sent it to you late last night, but because this building actually shares an address, it's one building, but it's 2533-2575 South Park Road per the Broward County property appraiser.
Mm-hmm.
It appears that most of the permits were applied for and passed all the inspections under 2575. So, I have here, I don't know if you can pull up your email, but I have the electrical permit pass, showing that it passed all the inspections. I have the AC permit. I have the awning permit. I have the, paint applications approval, because it's not technically a permit, but it's an approval from the town. And this, they were all issued back in 2021. So it may just be a matter of miscommunication. I mean, I know that you had checked with your building department, Jocelyn, but I think just the fact that it was under 2575, that may be the cause for the miscommunication. So, I do, want to relay that, my client has been acting expediently. They've taken a lot of steps to come into compliance. And I'd like to go through, one by one, some of the issues in each of the cases. So, as I mentioned, the business tax receipt has already been applied for. Jocelyn confirmed that she sees it from the town's end, which is great. It would be pretty simple, but obviously that's premised on the permits being approved. The electrical looks like it was approved under 2575. The illegal signs that are mentioned here, they have already been removed. So I think we just need to get an inspector out there to confirm that. But both of the signs that are mentioned in the violations were removed, if not in 2020, then in early 2021. And let's see here, let me pull up 5466. The cameras were installed without permits. We have confirmation from Tony that they're going to be removed. And then, the biggest issues are the storage racks and the mezzanine. So the mezzanine, Jocelyn, I know that you stated that it was built without permits, but, just a little, context, my client purchased the property with the mezzanine already there, and we actually were able to track down through Broward County a building permit from 1974 for an addition to the warehouse. It was reviewed and approved in 74, and thereafter the latest review was 1985 for the mezzanine. That being said, obviously that's been a major, a major issue for my client, because he does, use that mezzanine level, and it's important to the tenants. But, he did employ a structural engineer to review it, and, hoping that, we'd be able to keep it. And, ultimately, just within the last few days, he's determined that, no, he's going to go ahead and demolish it. But that, of course, is going to take time, along with the storage racks, which have to be, that the plans have to be redone through the architect. We need to hire a contractor. We need to apply for, permits from the town and, get the approvals, the permits approved, and then do the actual work. So, I mean, we're talking about, from, beginning to end, I think, probably minimum 150 days, to bring the mezzanine into compliance, to, demolish the mezzanine and do it in a safe manner and get everything approved. But, just a little bit of context for you. It's a little bit different because my client purchased it like that, and there was a permit that we tracked down from Broward County back in 1974. But yeah, I mean, just to reiterate, a lot of these things, I know, Jocelyn, you and I spoke yesterday, and I was sort of scratching my head, like, how could that be that there's been no permits? I'm, talking to my client, and, they say that there's permits, and then lo and behold, Iris did send me all of these, permits, which I emailed to you last night, Jocelyn, and they just happen to be under 2575. So, hopefully that would, change your perspective and recommendation, Jocelyn, now that you can see that we have been, working on these issues for the past year and a half.
Okay. Yes, I saw your email briefly last night. However, those are mechanical permits. That means AC units. There is no mention on the violations about AC units. Now, as far as the electrical permit, I'll have to verify what it was for based on the plans that was submitted. So, of course, the time was not given to me to review that electrical permit. But still, my, words then, there's still no permits for the items on the violation. And as far as the removal of the sign, you still got to get a demolition permit. There is no demolition permit for the signs that were removed. And the electrical cameras that are going to be removed does require a demo permit as well.
Right. So, I mean, as far as the, the removal of the cameras, obviously we'll apply for a demolition permit. What I'm seeing here in these permits is that they passed all of the relevant disciplines.
For a mechanical, but there's no mention of mechanical violation in the violations that I discussed. There's no violation for mechanical, is what I'm saying. Mechanical it's for AC, so there is no violation for an AC here.
Right, but that was only one of the permits. If you, for instance, the awning, the awning.
There's no violation for the awning on these cases.
Well, it's for work done without a permit. It's a little bit ambiguous in what's listed here.
There's nothing listed for awnings, is what I'm saying. There was a violation in regards to that, but that's not what we're presenting here. That violation hasn't even gone to magistrate for that reason. So the items that we're discussing is mostly
65, and you scroll down, and I think you had mentioned this. It says altered number 3, altered electrical without permits.
Yes.
But then I'm looking at the electrical permit pass, and it shows that all the disciplines had approved it. So it's
the electrical permit. That's what I said. The electrical permit, I haven't been able to review, the plans and what is, tied to. So that's the only one I'm agreeing to. But I'm saying the mechanical permits and the awning permits have nothing to do with these violations that I presented.
Well, the demo here for permit for removing canopy, that's when we have.
Which one?
On number 6, removing foundation sign, that also is
That's the
part.
sign. That's nothing to do with the canopy.
Yes, but before we had the awnings and the painting done, we did have call about removing signs and.
Yeah, because there's another violation that's not presented, that has not been presented to the magistrate. That's probably it's another case that I recall, but it's not, none of these here.
Those are all related to 2533 and 2575, because that's where we applied for those permits for the awning
And
and the
so
painting of
when
the
you said
building.
that you removed the awning, did that include the Stratton sign as well?
That's all, yeah, included with the.
Okay, then I will have to, I'm sorry.
That would be, that's all included when we
The
applied
ca-
for the awnings. to
Hang
be
on a second,
installed
the call drop.
And the painting of the building.
But there's no painting violation.
I know, but removing the signs was part of when we applied for the
Okay.
painting, and we had Miguel out there and approved removing signs to paint the building.
Hang on, Iris, because
Oh,
he's
sorry.
not on the call.
Okay.
So he's gonna miss everything you're saying.
Kind of, I do the same thing. Sometimes I press the wrong button and he goes off.
No, is that I don't have reception.
Oh, okay, all right, well.
Call drop.
Well, I still sometimes press the wrong button, so.
I play with my chica.
Hi, Jocelyn. Thanks for calling me back.
Hi, sorry, the call drop. Okay, so what Iris is explaining to me is that the foundation sign and the Stratton sign were tied into the same permit, so I will look into that one, but that's just for item 6 and for the other, which was on 2575. The removal of Stratton sign, she says that there's a demo permit, so I will have to look into the plans that were submitted.
Right. So we have the electrical, we have the signs, and then, obviously the two big ticket items are the mezzanine and, the storage racks. And, as I explained, it's, with a little bit more context, the mezzanine, it's not that my client built it without permits. It was permitted by the previous owner, and it's been existing there. And, just recently my client did decide, look, in order to, work with the town, and because he's been an owner in the town for, I think, almost 40 years, ultimately he, decided that he is going to remove that mezzanine. But that is going to take time. So, I think 45 days is just not sufficient. And, obviously, I think you can see that, my client has been, attempting to, come into compliance. There's still some outstanding items, but clearly, many of them have either been resolved or they're in the works. They're, they're moving forward.
I still stand with the 45 days
Okay.
for each case.
All right, what I'm going to do is I'm going to try to make a universal or entire matter so that everybody doesn't get confused and one is not contingent on the other.
Special Magistrate, is it all right? My client from Israel would like to,
Sure.
I guess, yeah, thank you so much. Tony, did you want to say something? Iris, do you have Tony on the line? Well, I'm sorry about that. I know he does want to say something, but I think it's just hard because he's out of the country. But he, I think I would just relay on his behalf that, he is acting in good faith. He wants to come into compliance. And, Jocelyn, obviously, we really appreciate your efforts and your team's efforts. And, we want to work with you and, figure this out as quickly as possible.
Right.
But obviously, it's going to take time. So I'm sorry, Special Magistrate.
That's okay. I mean, it's a 6-hour or 7-hour differential
If
there.
I can say something, Magistrate,
Yes.
all the issues that are pending in regards to the smaller violations, I think we've addressed and can finish within 45 days. If we finally come to the resolution that we're going to close off that second floor, it's going to take some doing, and I don't believe 45 days would be enough. Everything else shouldn't be an issue, but if we get into electrical issues, of course 45 days won't be enough because, again, plans and approvals are back and forth, and we've experienced this now with the city, with other properties, that, you know, it's taking a long time. They come and they approve or they don't approve, and 45 days just won't cut that particular part of the project.
Okay. All right, now, what I'm going to do, I understand there seems to have been some progress made. It is a long-standing case. What I'm going to do is, I think for all three cases, I'm torn between 60 and 90 days to comply. No, not higher.
All right, Your Honor.
No, let me, between 60 and 90 days for everything, to get everything.
And they come to do an inspection or a review, an inspection, and we fail, and we have to change the process as far as on the
Well, I know, but here's the thing.
we have to send it back to our architect. I just want to not be in the same position whereby because we're doing that and the time has expired, we're going to be in violation. We are in process. We got to give us some time to get this thing worked out.
Yeah, I know, but here's
or any other building.
here's the
We're
problem.
not trying to do it, you know?
Hold on, Tony.
And so here's the problem that I have. It has been a case, 2020. It's been going on. It sounds like there's a lot of stuff to do, and the like, and it needs to get taken care of. That's really the bottom line. So what I can do is either go with 60 days, and let me hear the argument about 60 or 90 days. If you show good faith, the city may agree to extend that more time. That's if you show good faith and do what you're supposed to do. It's just that, you know, this thing is dragged on.
We will show good faith and we'll continue to show good faith. We have plenty of permits.
I know, that's why I'm doing this. That's why I'm doing this. Otherwise, you know, the code officer is very diligent. She's thorough. She'll review what has been sent to her yesterday, among other things, and narrow down what needs to occur. It just sounds to me that there isn't that much more. If everything you say is accurate, and I'm not saying it is or it isn't, but assuming that it is, then you really should be able to take care of this pretty expeditiously. And yes, the city may very well reject a first or second attempt, but at least you'll have made a good faith effort to get it taken care of. So there's always the back and forth.
If you give us the 90 days, we'll show you proof plans and permits immediately. Within a week or two, 3 maybe, we'll put it in.
What's your notion? 60 or 90?
I'll leave it up to you because
the actual
I'm
drawing
sticking with.
and the electrical planning, so those are not in our hands.
Okay, is this, so that we don't have to come back earlier, I don't know, I'm really torn between the 60 and the 90 days.
We prefer the 90 if that's
I
like.
know, I understand that.
And I mean-
Trust me, I know what your position is. You want 150 days.
I'll do 365.
I know,
I mean,
no,
I'll
I
do
know.
365. You
can't.
tell me.
I know, I do. Okay, I'm gonna give you 90 days.
Thank you.
No, it's
Thank
okay.
you. Thank you. Thank you.
Give you
Thank you.
90 days for everything,
Thank you.
okay?
And is that possible chance in case worst scenario for extensions after
Okay,
90?
you two of you talking, I get to now act like.
One second, Mr. Shear.
Yeah,
One
just
at a
second.
time, one at a time.
I now get to act like a real judge, which I'm not. You can't have everybody talking
didn't even
over
know he was
another. I know, they say that all the time. No, go ahead, you, Counselor, go ahead.
You can crack your gavel.
I don't have one, no, it's okay, go ahead. Okay, I'm gonna go with 90 days for all three, or 250 a day thereafter, all right? So you need to get this thing going, and there has been work done, and kudos, praise to what the city code officer has done as always. And you too, I hope your wife recovers and she got vaccinated beforehand, but that's between you and her and whoever else. But I'm going to go, that's okay, 90 days for everything, okay? Don't disappoint me or else, you know, or else, okay? 90 days, all right? Just get it done, all right? You seem to be on top of things. That's the bottom line here. So I'll find that there's substantial competent evidence to support the city's position for all three cases. I'm going to, in all three, 5445, 5466, 5465, you'll be given 90 days from today in which to comply, or $250 a day thereafter, okay? So that's basically what I'm going to do, or that is, we're going to give a copy of these to your colleague here, and she can send you a copy as well when she email it or faxes out. No such thing anymore, I guess. Anyway, so within 90 days, or $250 per day.
Okay, thanks, Jocelyn, and thank you, Special Magistrate.
Sure. All right.
All
Take
right,
care,
have a-
everyone.
Get better and have a good day.
Yeah. Within. Screw this up. Get it all in one. We just double check to make sure that it's 90 days or $250 per day thereafter. There you go. It's okay. Make it, try to keep it easy. So if there is such a thing in any of these cases, there isn't, but.
All right, Mr. Magistrate, it'll be, next case is 5840. It's going to be on the last page, page 8. It'll be agenda item 13.2. Case number 5840, property owner identified by Paradigma Corp., site address 5100 Southwest 41st Street, Pembroke Park, Florida, Unit 219. This property came into compliance on 6/21/2022.
Great.
A notice of formal hearing notice of formal hearing to abate the fine was issued on 7/5/2022, posted to property and town hall on 7/7/2022, and sent out certified mail on 7/5/2022. The total fines accrued was $12,400. It is the town's motion to abate the fine by 90%, which will be $1,240 plus the $100 admin fee, for a total of $1,340.
Good morning.
Good-
Good morning.
Yeah, closer there. Okay, great. Yes.
My name is Bettina Rassi.
Yes. Okay.
Well, one of the things that I wanted to mention is that I was here last month, and we came into compliance at the same moment when the property was signed for foreclosure. It was like at the same time, actually. It took us like a year to open the permits. It was very, very tough. It was very tough because this property that is under a company was part of my sister that passed away. So the paperwork was not even available. So for me, it was very complicated to try to trace everything to make it correctly. I have been for more than a year a foster mother. I'm not even working, so to take the time to do this was very, very tough. My question is if the fee can be reduced a bit, if possible. And the other thing is, how do we do to cancel or dismiss the foreclosure action?
You'll need to pay this, that's how, because
Okay.
I don't think the foreclosure action's been filed. I think what happened was that all the people were just not doing anything, and then all of a sudden, when they heard about the foreclosure action, everybody woke up. So, I mean, that's just the way
Well,
it
not,
goes.
not our case, because we were working with the city for the full year. Very, very difficult
Okay.
to open the cases.
All right.
Open the permitting, actually.
Okay, I'm just trying to see what the violation, kitchen renovation, electrical out multiple areas, bathroom renovation, AC change without a permit, unit. Okay, all that was taken care of. Okay, all right. What I'm gonna do is this where you live?
No, the property is a rental, and to be on top of it, I don't know, you might be aware that building put at a special assessment of $35,000 per apartment, payable in 6 months. It's killing us, you know? It's very, very tough.
Well, that's for everybody, right?
Yes,
Okay.
every
And how
single
many-
apartment.
How many unit owners are there?
I think it's 1.4 million, the special assessment that they put, or something
Yeah,
like that.
I
So
know, but-
there are 60 owners, something like that.
Okay, so everybody,
Terrible.
how much does everybody pay?
Well, everybody is 30-something thousand.
Okay.
So I don't know if everybody will pay it, because it's kind of
Yeah.
difficult to pay that in 6 months.
Okay, is this a condo, a townhouse?
It's a
or-
condo, yeah.
Okay, all right, well, what I'm gonna do under the circumstances, and the like, it's been reduced by 90%, $1,340, I'm gonna reduce it to $1,100, okay?
Thank you.
All right, that way, you get more of a reduction. If it's not paid, it reverts back to 12,000.
No, I'm gonna go and pay it now, so
Good.
it's finished.
All right, so you get a
So
little.
about the foreclosure comes immediately, or I have to request something
I
again?
don't, I think once you pay it, it's over, okay? But
Okay.
you'll need, so I said $1,100,
Okay,
okay, payable within, I'm gonna put down 30 days, okay? You're gonna pay it immediately, that's good.
yes, I'm gonna go and pay it now.
11, okay.
Okay, I appreciate
That's okay.
everybody. Thank you so much.
Okay, just wait around for a few minutes because.
I will. Thank you.
Okay. That way you can take it over to whoever and pay him now, all right, if you want. Reduction to. Okay, $1,100 payable within 30 days, which means, anyway, you say you're gonna pay now. So here, make a copy, I've signed off on it, and that's basically it. All right, good luck to you, ma'am.
Thank you so much.
Sure.
Right, the next case is on section 7.10.
I wonder if, I know you've been waiting here a long time, if, I don't know how long, could we just take a 5-minute break?
Sure, of course.
Okay, all right, this is 7.10, all right. If we could just do that, I'd appreciate, because I've been sitting here for 3 hours, and we all have, that way we'll go.
We are ready.
Go ahead. Thank you. Took a few minute break.
Good morning.
Good.
Good morning. Okay,
Hi,
so
Jocelyn, nice to meet you. We are the new owner of the, you know the story, or just to remind you?
Yes.
It was the Daniel Antiques place. We just bought it, and we just know about the violation, because when you do the search to get your title, they told us about the violation of the roof. We
okay,
didn't know there
let
is
me, let me
$100.
present the case.
Okay.
And then after I present the case, then you'll be able to state your facts, okay? All right, so the section is 7.10. That's case 7172. Chief Code Enforcement Officer Jocelyn Ramirez, case 7172, property owner Thai Group Inc., Site address 2520 Southwest 30th Avenue, Pembroke Park, Florida. A notice of violation and a notice of formal hearing was sent by certified mail on June 23rd, 22, posted to the property and town hall on July 7th, 2022. The violation was for a banner that was hung on the roof. Banners are prohibited. They have to remove the banners, so banner's still there based on my inspection on July 7th. So my recommendation is they have to remove it immediately. I'm going to give them 5 days. If not, $150 per diem with a $100 admin fee.
So it's already been removed and we took care of the roof and
It's been removed as of when?
like a week ago or something like that.
Okay, so you need to notify me when that happens. That way
Oh,
I can go and inspect.
Because we spoke to the realtor, I told him, listen, there is violation, he needs to take it out. He told me I'll take care of it immediately, so.
Okay, so if it is removed, as you say, I'll see if I can stop by late this afternoon if I have time. But you still have to pay the admin fee on this case. Okay?
Okay. All right, so I'm going to find that there's substantial competent evidence of the violation. They have 5 days in which to remove it if they already have not removed it. Oh, this is an order of abatement.
That's for case 7172?
No, it's okay. Fuck. That's okay. That's another case. Sorry.
5704.
That's all right. That's okay. So what I'll do is I'll give you 5 days or $150 a day, but you won't have to pay the $150 a day. You will have to pay the $100. Okay.
No problem.
5704?
No, the case is 7172.
7.
That's why. I'm sorry.
7172.
Thank you. There you go. I find there's substantial competent evidence for the city, the town's position within 5 days or $150 a day. Okay, one down. All right, we'll get to the next one.
The next case is 5704. And that's on section 8.8.
820, you said?
Chief Code Enforcement Officer Jocelyn Ramirez, case 5704, property owner Thai Group, Inc., site address 2520 Southwest 30th Avenue, Pembroke Park, Florida. A notice of formal hearing to abate fine was sent by certified mail on July 1st, 22, posted to the property and town hall on July 7th, 2022. Is the town's motion to abate the fine of $16,800 by 85%, and that would be a total of $2,605. That includes the administration fee.
Okay, your name just...
My name is Guy, and I'm going to explain you about the situation. We are the owner of this building since December 2021.
Right.
This violation is from March 26th of March 2021. So the violation is even before we own the building. Now, by the process that we purchased the building, she just told us about the violation. We didn't know about the $100 a day. But soon as we bought the property, first thing we did, it took some time to get material and took care of the roof. But
Right.
first thing we did, we signed a contract with the guy of the roof. So we didn't know about the $100 a day. If I knew it, I just came to this building and I was asking like 90 days or whatever everybody's asking, and I was taking care of it. But I didn't know about the $100 a day. This is why I'm thinking 16,800. It's like, and even 85% is too much because, I think 5% is fair because we took care of it. it wasn't our violation, and by the time we purchased the building, the girl probably, she lied to us. She didn't told us about the $100 a day.
Okay, you're Moishe Tayeb, T-A-I-E. Oh, you're Moishe. Okay, how are you, sir? And what is your name again?
Guy, G-U-I.
Okay, your last name.
Please speak it to the mic for the record. Thank you.
Hayun.
Okay, all right. Okay, they want to go with 85%. What I'm going to do is go between 5 and 15%, and I'll reduce it by 90%. Okay,
very
all right, no,
much.
that's okay. So whatever 90% is,
Can we pay it now?
pay now, absolutely.
You have to pay by check, but you can leave the check with Jeffrey. However, the whole affidavit of compliance and the invoice will have to be sent to you by email or by mail because we have to enter the order in the system.
We just needed by email we took a loan for the building. And
Okay.
they don't give us the loan until we're gonna clear this balance with the city. So I need it like as soon as we can, please.
And then by check, we also have to wait with the finance department. We have to wait 5 days so it
Can we pay by
clears.
credit?
Credit card, you will get a 3% technology fee. Okay, they still have to wait till it's entered in the system. I mean, they can give you an invoice.
Perfect. Thank you so much.
Yeah, let me get the exact amount. I can't pull up on my,
We combine both of the amounts together?
Oh,
That's
yeah, you can on the check.
so it's 16,800 times 90% we deducted, or actually times
No,
10%.
let me get you the total right now.
If you
You're,
wouldn't mind.
you're doing 90%?
Yeah, 90%, so.
So that would be a total of 1,770.
We're gonna make it 1,700 even, just to make it easier on everybody. All right,
Thank you so much.
1700. It's close, it's 1,700 even, all right? So you get a little less than 10%, all right? It's payable within 30 days. Although you can pay it whenever earlier, you know, whatever the rules are of the town, which I don't get it. So it's abated to $1,700 in 30 days.
Yeah, we give you the copy right now.
Section 27. Understand it, it'll revert back to 16,800 if you don't pay, okay? It needs to
Well,
be
we pay
paid.
now.
No, okay, all right. Thank you, sorry to keep you waiting, you know, we did whatever we could, so.
And if
that's
you wait a
all right.
moment, Nasli will give you a copy of the orders that the judge signed. Mr. Magistrate?
Yes, oh, yeah.
Guy, Hayun, and Moshin Tribe? They weren't sworn in. Should we swear them in right now?
I think it's too late, we
Too
don't
late?
need to have them. I'll tell you, you wanna just raise your right hand? You,
And as well,
Well,
Pat Brinson?
you. Okay, for the two gentlemen in front of me, anyway, do you swear or affirm that everything you've said is true, the whole truth, and nothing but the truth? The answer is, okay, great. And, sir, okay, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Yeah. Great, thank you. Take care, everyone. Be safe.
Yep, you're good. Better to go around, and then the front desk will guide you.
I don't say 6980.
Absolutely. So I'm sure you're all code enforcement out after today, so.
Okay, we're gonna go and start with section 10.3, case 5479. Chief Code Enforcement Officer Jocelyn Ramirez, case 5479. Property owner Pembroke Park Church of Christ of Broward County, Inc. Site address 3707 Southwest 56th Avenue, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail June 23rd, 22. Posted to the property and town hall on July 6th, 2022. It is the town's motion to confirm a fine of $15,350.
You're up. Your name, please.
Good morning, Your Honor. My name is Patrick Brinson. I'm a member of the Pembroke Park Church and also on the facilities ministry. So I'm here to represent the church. And
okay, go ahead. What's up?
Well, basically, yeah, this came about a year ago. We had several violations that we had to come into compliance with. One of them being a bunch of trash that still to this day, there's like a pile of trash that's sitting in front of the church because people in the area, they somehow, dump there. So I guess on a sidebar, I'll get with maybe Public Works or something, see what we can do to either get more signs out or something for them to stop, dumping. People also put cars out front and they list them for sale and stuff. And so the Pembroke Park property, church property is very beautiful, property, and we keep it up very well, and it costs quite a bit to do that as well. There was also tree trimming over the COVID time period. A lot of trees had overgrown. We had not been there having service or anything, so we had to bring that in compliance in order to the trees that overgrown into like the lines, the power lines and whatnot. And then there was also there was a stop sign in the front that had gotten damaged. It was down, and then two of our lights that got damaged by one of the hurricanes as well. So the stop sign, we did that. We did the tree trimming. We had the trash had been removed, I guess, by a boat pickup or something like that. And then the lights, we also removed those. So what ended up happening is we still haven't been able to replace them. We have two pillars that are in front of the church, part of the concrete gate. And on top of those two pillars, there were two light fixtures. So we removed the fixtures, and then we had the electrical to be capped off. However, we have not been able to replace those fixtures. I was under the impression that we were in compliance since we did quite a bit, and within a week's time to do the tree trimming, the trash, the lights, the sign, and all that stuff. And then we have put in to try to get these fixtures. Home Depot, Lowe's, and other people locally or the electrical supplies have these fixtures. And then where the ones we finally found that we wanted to use were on back order. And so it kind of just got lost in the shuffle. Meanwhile, this past year we just changed leadership with our minister, our previous minister Kevin Jones, moved to North Carolina, and so we have a new minister, Douglas Perry, right now. So it's been, quite a bit going on. At the same time, we're still not 100% back at the church. Our facilities director, he ended up having a stroke, and he's been out for months now. It's been probably shortly after that. So I've been stepping in and trying to fill in as well, and, other brothers as well. But, I just, I definitely didn't know about it, the fine, and that it was accruing like that, because clearly, from the we always try to, be in compliance and take care of stuff. We did that right away. So I definitely want to be able to either get this, I don't know, set aside, removed, or, address that some type of way. Is quite a bit.
Okay, here's what you're going to need to do. Someone at your church needs to stay on top of this, and I guess you're going to be the victim here.
Yes.
Somebody, okay.
Mhm.
And once there's full compliance, then you can come in for a mitigation or reduction.
Mhm.
I can't just vacate what's accumulated. It'll continue to grow until there's compliance. The quicker you get compliance, the lower the amount will be that you'll have to pay. You sound like there are some equitable arguments you can present at a future mitigation situation. You've seen what happens. The town, as long as there's diligence in getting compliance, they reduce it substantially, and in nearly every case that came in front of me, I even reduced it somewhat more. In your instance, all that you've gone through, you can save that for a future mitigation, but you have to be compliant before you can come back for a reduction. So comply with everything, then come back, request a mitigation reduction of the fine or abatement, and then we'll talk about how much it gets reduced. But you need to just go ahead and get compliance before you can do anything else.
Mhm. So my only thing is that even with this being like in a code issue, I understand the way it's gone, that it's still considered a code issue, because you guys considering to be in total compliance is for us to replace it, or to, they were saying, get a permit and remove the electrical, but that's clearly not what we're going to do. We definitely want to replace the light fixtures there. Whether they're there or not, you can't even tell that something is supposed to be there. So my thing is that it was an eyesore. Well, it was an eyesore before, because the fixture had been hit. It was leaned over. Now that they're removed and it's properly capped until we can put something on there, I just think it's very overbearing that there's even any type of fine or going on saying that, hey, we're charging you this amount a day for you to, put something there that's going to make the property just look better. It's not like there's still something there that is looking bad, or there's an eyesore. Everything that we had to do within it had been taken care of. And then again, for whatever reason, there's no way that any of us knew that we were accruing all of this.
Okay.
But
I understand that, but
same thing.
There's a reason for requiring permits. It's not only for aesthetics or beauty or how a place looks. You've enhanced it apparently, but you need to get whatever permits are required here, and apparently there's a number of them. Exterior structures, properly maintained fences, exterior walls, signage, or is this the one here? You have Pembroke Park Church of Christ of Broward County. There's just a number of violations, and they all, and the dead or dying trees need to be trimmed. Once you comply with everything.
No, we did. Everything's in compliance. There's nothing.
Okay.
Yeah.
Then you need to contact the code officer for them to go by and find out what's in compliance and what isn't in
The
compliance.
only item pending is the light fixtures that as he mentioned.
Okay. All right.
And, yeah, it was discussed a year ago. The building official said that if they are going to remove it, they have to pull a permit and remove all the electrical too.
Okay.
Because they cannot stay with exposed wires out in the open.
Do you have any idea how dangerous potentially exposed wires can be? I mean, you know, it can be very dangerous.
Yeah, I mean, potentially in any situation, but this here, the wires are, like I said, on top of a pillar. It's about probably 8 feet in the air. No one can access it, and then they're all capped off, and they're on top. So in essence, it's not, but I know if somebody grabbed a ladder and climbed up on top, you know, that wouldn't happen.
One day, you could be blessed to have Shaq come in and do that. I don't think he's 8 feet tall, but I understand he's very human-friendly. He doesn't mind. He's a giving person, but I don't think he wants to go that way. So,
No, definitely.
Or the Kareem Abdul-Jabbar, one of my favorite of all time.
He was a great.
Yes, he was. The Lakers in their heyday and post, before Kobe and after, before Kobe, of course. So anyway, so you just need to take care of that, get it done, all right? And then that way you can come back and you can reiterate what you're saying, and there will be a substantial reduction. So get it taken care of, all right, please.
All right, so I mean, I've got it, I've taken it all in, but even like say in general, like right now, once we go and I'm diligent at trying to find these fixtures, which are gonna have to be shipped in from somewhere if I'm lucky enough to get it within 30 days, that's still 30 more days that these fines are accruing. So I think it's real overbearing. And then even once we go to a percentage.
What happened to the light fixtures that were on back order?
They ended up now, they came out, which happens all the time. They're not available anymore. So now we have to find something totally different. Yeah. So it's just an unfortunate, because again, you know, these are not, they're commercial style, bigger, you know, black, not chrome, like iron type, you know, lighting fixtures that need to be replaced there, so they're not common at all. So there are very, very few vendors that have them and want to have them. Either they're just ridiculously priced or can't get them. So, you know, another 30 days, which I'm not sure if it can be, you know, because I don't want to just go and get something just to put up there, just say we put it. Because again, these are tall, big pillars, and right now without them there, it's not hurting anything. So I just think it's over and beyond for fees to still be going on. So could we at least pause that and we still come back and do it later?
The way that'll be handled is if the mitigation in the future, the total amount will get reduced. Just get it. I can't stay it. Okay, so I can't stop it from accruing. It's the only way that this is going to get done. If people don't, and a company doesn't feel like there's a growing fine, we don't know how long these things will take to comply. So you need to get it taken care of. It'll continue to accrue until that time. So just get it taken care of. Anyway, in this instance, I'm going to have to confirm the fine at $15,350. Once there's full compliance, request a mitigation, abatement, reduction of fine, and we'll take it up there. All right?
All right.
I know you're not happy, but most people aren't, you know. That's what makes my job so fun. Not really, you know. I mean, I do the best I can, but I'm bound by what the statutes say, what the ordinance say, what the code says, what the law says. So it needs to be confirmed here. So get it taken care of, you know, or get another style of these electrical matters, you know, if you can get another one quicker. Do it that way, you know, it's up to you, all right?
All right, yeah, I was just running through my head trying to think how it still is, you know, the eyesore, that's one thing, but once that's addressed, I'm still trying to get how
I know, but it's not just aesthetics or how it looks, it's safety as well, all right? Safety features. Aesthetics, yes. Safety features, all
And
right?
it's safe because just like with other, and again, not to prolong it, but
that's
say if
okay.
there's a light fixture and we take the bulb out, there's nothing wrong with having a light fixture there about a bulb. We have to replace the bulb.
Please comply. It'll just make life easier for you and whoever sits here, whether it's me or the other gentleman as a magistrate. So, all right, get it taken care of. All right, I'm going to go ahead and confirm the fine. Okay, just get it taken care of. I can't stay the fine. I'm just not going to do it. I just don't think it's right. The only way this will get taken care of is if there is a fine that accrues. Just get it done, that's all. You've done so much work. And you're a religious individual, that's great. So your leader will be proud of you, okay? All right? Take care, all right? Get it done.
There's also another case for Pembroke Park Church of Christ. Are you going to stay for that, Ms. Brinson? Mr. Brinson? Chief Code Enforcement Officer Jocelyn Ramirez, case 7174, property owner Pembroke Park Church of Christ of Broward County, Inc., site address 3707 Southwest 56th Avenue, Pembroke Park, Florida. A notice of violation and a notice of formal hearing was sent out by certified mail on June 23rd, 22, posted to the property and town hall on July 6th, 2022. The violations were for a trailer sign, a banner sign that was put in front of the property. Those have been removed as of July 6, 22, based on my inspection. The other violation is for expired permit on commercial AC changeout. Since the permit expired, that is considered work without permit, so therefore a new permit has to be obtained. At this time, I'm not aware of a permit that's been pulled for that. But I know that Mr. Brinson mentioned that it will be taken care of. And also, I know that our town attorney, Melissa Anderson, has been in contact with an attorney that is working on these cases. And there's a settlement, a stipulation. So I'm going to be inclined to give them the same amount of time to comply as the stipulation, which is 90 days, if not a $250 per diem with a $100 admin fee.
Okay, what number, this is like a 10 point whatever or an 8 point, do you happen to know?
I'm sorry? On the agenda?
Yeah, on the agenda, yes.
That's section 7.11.
Thank you very much. Go ahead, you're up. Okay.
Okay, yeah, I mean, that's fine. Like she said, there's an attorney, they're working with that.
Great.
There's an existing pilot agreement that's being negotiated, and they're going to continue to work on that and take care of it.
Okay, 90 days, did you say 250 a day or no? Oh, 250.
250 a day.
Per day. Okay, if they negotiated it, I would feel bound by it as well. So, and that's just really the best way. One player I didn't mention it, I always liked was LeBron James too. He's tall, but not as tall as the others. I don't want to forget equal time to some of my favorite athletes. So there's substantial competent evidence to support the city's position. 90 days to comply or $250 per day thereafter. The
Yes.
prior case, just get it done.
Definitely.
Please, just do it. And this one as well. All right?
Definitely.
Okay?
All right, John.
Thanks for waiting around. Take care. Be healthy. All right?
Thank you so
Take
much, you
care.
guys.
Take
too.
care.
I appreciate
Be
it.
safe.
Thank you,
Right.
Officer Ramirez. Thank you.
Sure.
Y'all take care. Do I need to get?
Yeah, Leslie will provide you with a copy of the orders.
All right, who's buying lunch?
With the great deal that you're getting, no, I.
Okay, Mr. Magistrate, so that was the last person on the audience, so we're gonna go in chronological order of the agenda. So we're gonna start with, section 7.1.
9, what was that, 9 point,
7.1,
oh, 7 point,
first page of the agenda.
great, okay, 7.1, okay, that was with 90.
Yeah, we need to continue here.
Thank you, there you go. Oh, yeah.
Since you guys still have to stay out, I'll have something for you. I think you guys.
Oh, okay. Meantime.
Good luck, take care, be safe, all right. That's okay, get it done, really, please.
Yes, sir, I will.
All right, please, all right. Thanks for your, did I
By
forget any
Officer
basketball
Reyes.
players that were great? Larry Bird, he's Boston, I wasn't really into Boston's. Okay, I was into Boston, no, I'm kidding.
Let the
They
rec-
came close this past year.
Let the record show that
Next time.
Officer Reyes left at 12:40 p.m.
Take care, thank you so much for your help, thank you. Gotta watch what I say these days, anytime.
Okay, so beginning with section 7.1.
7.1, 542.
Okay. Chief Code Enforcement Officer Jocelyn Ramirez, case 5439, property owner 3163, building LLC, 3163 West Liquors LLC, site address 3153 West Hallandale Beach Boulevard, Pembroke Park, Florida. Notice of violation was sent by regular mail on November 10, 2020. A notice of formal hearing with a copy of the notice of violation was sent by certified mail on July 1st, 22, and posted to the property and town hall on July 7, 2022. The violations were for 2 aluminum signs that were installed without a permit. As of July 18, there is still no permit in the system for these signs. The tenant did remove these signs, but they still have to obtain either an after the fact permit for the demo, or if they're gonna install it, they need to obtain a permit. So my recommendation is to give them 30 days, if not a $250 per diem with a $100 admin fee.
Okay, based on the testimony of the code officer, there's substantial competent evidence to support the town's position. They'll have 30 days to comply or $250 per day thereafter. Thank you.
Right. On the second page, section 7.3, case 5454. Chief Code Enforcement Officer Jocelyn Ramirez, for the town of Pembroke Park, case 5454, property owner Pembroke Road Center LLC, site address 3930 Pembroke Road, Pembroke Park. A notice of violation was sent out by regular mail. I'm sorry, it was handed on November 18, 2020, and sent out by regular mail on November 20, 2022. No, I'm sorry, 2020. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on July 1st, 2022. Posted to the property and town hall on July 7th, 2022. The violations were for removal of 2 old channel letter signs and installation of 2 new channel letter signs without a permit. As of July 19, the expired permit that they had previously worked on has been reinstated, but inspections still need to be completed. So I'm going to recommend 30 days to complete it, if not $250 per diem with 100 admin fee.
Based on the testimony of the code compliance officer, substantial competent evidence to support the city's position, they'll have 30 days in which to comply, or $250 per day thereafter. Thank you.
Next case is section 7.8, case 5467. Okay, Chief Code Enforcement Officer Jocelyn Ramirez for the town of Pembroke Park. Case 5467, property owner Francois Charbonnet, Judith Charbonnet. Site address 323 Marine Drive, Pembroke Park, Florida. A notice of violation was handed on December 1st, 2020, sent by regular mail December 2nd, 2020. A notice of formal hearing with a copy of the notice of violation was sent by certified mail July 1st, 2022, posted to the property and town hall on July 6th, 2022. The violations were for a demolition of drywall without a permit, an addition of a bathroom and closet without a permit, alteration of electrical and plumbing without permit.
Thank you. Go ahead. No.
There is a permit in the system, but it is expired. So I'm going to recommend that it gets corrected within 30 days, if not $100 per diem with a $100 admin fee.
$100 per day, 30 days, great. Okay, substantial competent evidence to support the city's position. They'll have 30 days to comply, or $100 per day thereafter. Thank you.
Next is section 7.9, case 5528. If Code Enforcement Officer Jocelyn Ramirez for the town of Pembroke Park, case 5528, property owner Lapco Real Estate LLC, site address 3149 West Hallandale Beach Boulevard, Pembroke Park, Florida. A notice of violation was sent by regular mail on February 24, 2021. A notice of formal hearing with a copy of the notice of violation was sent by certified mail on June 24, 22, posted to the property and town hall on July 7, 2022. The violations were for an emergency repair of septic tank done without a permit, electrical work done without a permit. At this current time, there is no permits for the work that was done, so I'm recommending that it get done in 30 days, if not a $250 per diem with a $100 admin fee.
Based on the testimony of evidence of code compliance officer, there's substantial competent evidence to support the city's position. 30 days to comply, or $250 per day thereafter. Thank you.
The next case is on section 8.3. Case 4634. Okay, Chief Code Enforcement Officer Jocelyn Ramirez for the town of Pembroke Park, case 4634. Property owner Lakeshore Mobile Home Park LLC. Site address 147 Janice Boulevard, Pembroke Park, Florida. A notice of formal hearing to abate fine was sent by certified mail on July 1st, 2022, posted to the property and town hall July 7th, 2022. The respondent agreed to the town's motion, so therefore they're not present at this time. It is town's motion to abate the fine of $37,388.50. We're gonna reduce it by 85%, so the total is $5,726. That includes the administration fee and the recording lien fee.
Okay, they've agreed to this, and I'm going to go ahead and enter order of abatement to $5,726 payable. Did they say 30 days, or did they say when?
30 days.
30 days, great, okay. I'll do 7, 6 within 30 days. Reverts back to $37,388.50, but they'll pay. There you go. Thank you.
Next case is section 8.4. Chief Code Enforcement Officer Jocelyn Ramirez, case 4793. Property owner Ever Argueta, site address 107 David Drive, Pembroke Park, Florida. A notice of formal hearing to abate fine was sent by certified mail on July 14, 2022. In this particular case, the mobile home was completely demolished because it was involved in a fire. So therefore, it is the town's motion to abate the fine of $19,200 and abate it to $0, and the only thing that they will owe is the administration fee of $100. So the total is $100.
So I'll go ahead and abate it to $0, payable within inapplicable.
Well, I think you have to put 100.
Okay.
So the admin fee is collected.
All right, let me write that in then.
Okay. And the property owner agreed to it, so therefore they're not present.
Administrative. $100 shall be paid. I'll initial that, no big deal. All right. Got it. Abated to 0, but administrative fee of $100 shall be paid. And I'm writing it in here, and I initialed it. That should be enough.
Next case is on section 8.6. Chief Code Enforcement Officer Jocelyn Ramirez for the Town of Pembroke Park. Case 5166, property owner Michael Sanchez Avila and Veronica Mendoza. Site address 3423 Southwest 52nd Avenue, Pembroke Park, Florida. A notice of formal hearing to abate fine was sent out by certified mail on July 1st, 2022, posted to the property and town hall on July 6th, 2022. It is the town's motion to abate the fine of $7,200 by 90%. So the total amount is $810, and it includes the $100 admin fee.
Okay, I'll go ahead and abate it to $810 within 30 days?
Yes.
Okay.
And again, the property owner is in agreement with the town's recommendation, therefore they're not here today. Okay.
Yeah, I'll abate it to $810 within 30 days, or it reverts back to $7,200. There you go. Thank you.
Right. Next case is on section 8.7. Chief Code Enforcement Officer Jocelyn Ramirez, case 5302. Property owner Viking Enterprises V LLC. Site address 5434 West Hollandale Beach Boulevard, Pembroke Park, Florida. A notice of formal hearing to abate fine was sent by certified mail on July 5th, 2022, and posted to the property and town hall on July 6th, 2022. It is the town's motion to abate the fine of $14,700 by 85%. So the total amount is $2,290, and that includes the $100 admin fee. The property owner is in agreement with the town's motion, therefore they're not here today.
Okay, I'll abate it to $2,290 within 30 days.
Yes. And that concludes all my cases.
Great. A lot of action today for you.
You're getting your money's worth.
Yeah, no question. The town definitely is. Everyone is. So I'll abate that one, $2,290. Otherwise, it reverts back to $14,700. There you go.
All right, Mr. Magistrate, agenda item 11.1, case 6951.
I just want to say, we haven't forgotten about you, don't worry. But you should say 11.1?
Yes, sir.
Great, okay.
All right, case 6951, property owner identified by Frakes Donald Ray, site address 2617 South Park Road, Pembroke Park, Florida. Sorry. To be in violation of, there was exterior wall discoloration that has been removed. The parking lot in the back of the building is in disrepair, and the parking lot in the back of the building needs to be restriped. The notice of violation was issued on 4/14/2022, sent out regular mail on 4/15/22. A notice of formal hearing was issued on 7/5/22, posted to property and posted to town hall on 7/7/22, and sent out certified mail on 7/5/22. I have been in contact with the property owner. I'm going to recommend 60 days. If not in compliance, a fine of $100 per diem with a admin fee of $100.
Okay, based on the testimony, evidence, and code compliance officer, there's substantial competent evidence to support the city's position. They'll have 60 days to comply or $100 per day thereafter.
All right, agenda item 11.3, case 6953. Case 6953, I'm Code Officer Richwagen, representing the Town of Pembroke Park. The property owners identified by Reeve Asset Management Company. The address is 2501 South Park Road, Pembroke Park, Florida. The property is in violation for the exterior wall of the building has discoloration on it, which has been corrected. The entire parking lot is in disrepair, and the entire parking lot needs to be restriped. The notice of violation was issued on 4/15/22, sent out regular mail 4/15/22. Notice of formal hearing was issued on 7/5/22, sent out certified mail 7/5/22, posted to the property and to town hall on 7/7/22. And on 7/5/22, an affidavit of noncompliance was issued, showing that the exterior wall maintenance had been corrected, but that the other violations stood, and was sent out regular mail on 7/5/22. It is my recommendation to give them 60 days to come into compliance. If not, a $100 per diem and an admin fee of $100 be assessed.
Great. Based on the testimony of the evidence compliance officer, I'll go ahead, enter a final order giving them 60 days in which to comply, or $100 per day thereafter, and of course, as always, the $100 administrative fee.
All right, agenda item 11.6, case 7128. I'll have it put into the system, so I have the physical copy if you need to see it.
Yeah.
I don't have this one here.
Oh, that one already went. That was the guy who was talking. All right, case number 7128. I am Code Officer Richwagen, representing the Town of Pembroke Park. The property owners identified by Cote Claude J. Address 154 Marine Circle, Pembroke Park, Florida, lot 588. The violations were for hurricane shutters being installed without a permit, windows that have been changed out without a permit, and sheds that have been installed without a permit. The notice of violation was issued on 5/26/22, sent out regular mail on 5/27/22. Notice of formal hearing was issued on 7/5/22, certified mail 7/5/22, posted to property and to town hall on 7/7/22. I did speak with the property owner. They are in Canada. The recommended time that they were asking for, I can't go with, but because he is an older gentleman, because he is going through some hardships, because he lost his wife, I believe in this scenario that I would like to grant 90 days.
Okay.
And for the fine, I would say $100 a day per diem.
Will do.
Let me correct that. Instead of 100, I'm going to knock it down to $50 a day with the admin fee of 100.
Do you have any whiteout? I wrote $100.
She'll just reprint it for you.
They'll,
Yeah, she'll reprint it for you.
okay, could you, and then okay.
Just
I think it looks good at 50. I changed it, so. There's substantial competent evidence to support the city's position. 90 days to comply or $50 per day thereafter, and a $100 administrative fee as well.
All right, agenda item 11.8, case 7160.
Okay, all right. There you go. Thank you.
All right, Mr. Magistrate, agenda item 11.8, case 7160. Code Officer Richwagen with the Town of Pembroke Park. This is case 7160. Property owner identified by Trinity Broadcasting of Florida, Inc., site address 3300 Pembroke Road, Pembroke Park. They're in violation of demolition of structures without a building permit for lots 236, 245, 350, 448, 451, 529, and 539. The notice of violation was issued on 6/6/22, sent out regular mail on 6/7/22. Notice of formal hearing was issued on 7/5/22, sent out certified mail on 7/5/22, and posted to the property and town hall on 7/7/22. This is a repeat violation. I have spoken with the property manager, Kevin. They have gone ahead and submitted the permits for these, although it's not complete. So I would recommend 60 days to come into compliance. Otherwise, a fine of $500 per diem with with an admin fee of $100 attached.
Okay. All right, based on the testimony of the evidence of compliance officer and it being a repeat violation, 60 days in which to comply or $500 per diem for each day the violations continue to exist on the date of compliance, and a $100 administrative fee.
Agenda item 12.1, case 4630.
$500, oh, yeah.
Yes.
Yeah.
No,
It went over my head.
no, I did.
Yeah, yeah.
I did.
Good, quick. Yeah, you said 500 in the last page.
Yes.
Yes,
Yeah,
because they are a repeat
violation.
violator.
No, that's why. No, it can actually go back to the date of non-compliance, but you're not even doing that to be fair. Being nice, actually, so. you
Well,
know.
he did put in all the permits for
okay.
it, so
So they're
showing good faith.
Trinity always, they may mess up, but they act in good faith, that they'll get the job done, so, okay, thank you.
No problem. Code Officer Richwagen, representing the town of Pembroke Park. This is case number 4630. Property owner identified by Discount Auto Parts, Inc., Advanced Stores, CO, Inc., number 9479. The address is 3000 West Hollandale Beach Boulevard, Pembroke Park. This is for Elegant Beauty Supply. The violations were for an overloaded dumpster in the back of the property, portable container in the back of the property. Portable containers are prohibited without proper permits. Maintenance of building, side of building, and roof siding is damaged and must be repaired. Maintenance of property, overgrown vegetation around that. Window signs are covering the entire window. This is a hearing to confirm fine. The affidavit of compliance was issued on 7/7/22 and sent out regular mail on 7/7/22. The notice of formal hearing to confirm fine was issued on 7/5/22, certified mail 7/5/22, and it was posted to the property and a town hall on 7/7/22. The total accrued fines are $42,400.
Okay, I'll go ahead and confirm the fine at $42,400.
Correction, real quick, for the affidavit of compliance, the affidavit of compliance was issued on 7/7/22, but it has not been sent out yet. So I just want to correct that for the record.
Okay.
It was not sent out, and will not be sent out until the case is closed and the fines have been paid.
Right, exactly. Okay, they'll, well, there's compliance, but there's no compliance yet.
No, there is compliance. They've complied, but they just have to, they have to mitigate the fine and then pay for it.
I got you. Okay, sorry, there is compliance, so, all right, very good. So there, paragraph 4 says, the said fine shall continue to accrue until respondent complies with the final order entered in the by the special magistrate. I guess I could still leave that in because they've complied, right? Okay, all right, so it's $42,400, that's fine, and they can come back for a mitigation if they want.
Yes.
Great, thank you.
Agenda item 12.2, case 4635. Code Officer Richwagen with the Town of Pembroke Park. This is a hearing to confirm fine. The property owners are identified by Lakeshore Mobile Home Park, Miss Deborah Lisa Vaughn. The site address is 135 Stevens Street, Pembroke Park, Florida. The notice of formal hearing to confirm fine was sent out on 7/5/22, certified mail on 7/5/22, posted to property and a town hall on 7/7/22. The total accrued fines are $21,750.
Okay, I'll go ahead and confirm the fine at $21,700.
The $21,750, Mr. Magistrate.
Okay, $21,750, not $2,100,700. Okay, I'll just cross it out. Concerned fine of
$750. 750.
$21,750.
Okay.
I'll just initial it here. Cross it out and initial it, and that's 750. Move on, I'll just.
Okay, yeah, I just don't want to move on too quickly for you. All right, agenda item 12.4, case 5619. Code Officer Richwagen with the Town of Pembroke Park. This is a hearing to confirm fine. The property owner is identified by MS Invest US LLC. The address is 5100 Southwest 41st Street, Pembroke Park, Florida, Unit 108. The hearing to confirm fine was, the notice of formal hearing to confirm fine was issued on 7/5/22, sent out certified mail on 7/5/22, posted to property and a town hall on 7/7/22. They are still not in compliance, and the total accrued fines as of today are $17,150.
Not 17,100, so $150. All right.
Yes, sir.
Okay, I'll go ahead and confirm the fine at $17,150.
The The next case is Agenda Item 13.1, Case 5623. This is a hearing to abate fine. Sorry, real quick. Code Officer Richwagen with the Town of Pembroke Park. This is a hearing to confirm fine. Property owner Ketchum, sorry, to abate fine. The property owner is identified by Ketchum Tyler, site address 5455 Southwest 41st Street, Pembroke Park, Florida. A notice of formal hearing to abate fine was issued on 7/5/22, sent out certified mail on 7/5/22, posted to property and to town hall on 7/7/22. I have spoken with the property owner, that's why they are not present here today. They've agreed to the town's motion, and the town's motion is to abate the fine by 90%. The total accrued fines was $6,200, and when it's reduced by 90%, that's $610 plus the $100 admin fee for a total of $710.
Can you repeat it, please?
Sure. The total accrued fine was $6,200, but the town's motion to abate the fine by 90% reduces it to $610 plus the $100 admin fee for a total of $710.
Okay, thank you.
You're welcome.
30 days?
Yes, yeah, I spoke with them, and 30 days is more than enough for them to pay.
Great. Okay, so it's $710 within 30 days. Great. So be it. $710 payable within 30 days, or reverts back to $6,200.
That's good. Okay, so I got to correct it in icon, please. Then the last item is 11.2, case number 6952. They have come into full compliance, and the compliance date was,
Space, I'm sorry.
did I say the
Point
No,
two.
did I?
Point two? Thank
No,
you.
6952.
But what happened with that? Right. Oh.
Yeah.
Yeah.
All right, never mind. I had said that earlier. I just forgotten. This concludes my testimony.
Okay. Anything else? Comments, any additions, deletions,
719.
corrections? Otherwise, we can adjourn then? Okay.
1 second.
Oh, sure, go ahead, please.
There are some clerical errors on the agenda that we're just going to correct after the fact. Is that okay?
Okay, sure, okay. And you'll, what, for amended orders, or?
No, it's just more of a verbiage thing. For section 12.1 through 13.2, instead of saying the actual hearing to confirm fine, it was put as formal hearing, so we're just going to change it to the actual
Okay, but.
type of hearing.
I think when I signed the orders, they were signed as confirming fine.
Yeah, the
Right.
orders were correct.
Great, you're free to do that.
So it's more of a clerical
But
issue.
that's fine.
Okay.
Please do that at your convenience or whatever you like. So-
Okay,
Okay, anything else?
that is all.
Okay, we'll go ahead and adjourn at 1:17 and a half. No, 1:17.
1:18.
1:18, there you go.